is presently working as the Deputy General Manager, Employment Relations at the corporate headquarters of HPCL Mumbai. He joined HPCL in the December of 2003 after having a 4.5 year of practicing experience at the bar. He is heading a team which deals with service matters in HPCL and has a wide exposure of defending crucial labor-related disputes pending before Supreme Courts, High Courts, tribunals, ensuring statutory compliances, alternate dispute resolution mechanisms, and even handling departmental inquiry related matters. Under his leadership, HPCL has been conferred the Best Energy and Resources In House Team of the Year during the ALB India Awards 2021 by Thomas Reuters. After graduating in geology from Calcutta University, Shri Mukherjee pursued LLB and is a gold medalist in LLB from the University of Burdwan. He has also been certified as a trainer by the ISTT. He has conducted more than 250 workshops internally and externally in statutory compliances and departmental inquiries. He is one of the finest resource persons for conducting a workshop on departmental inquiries under the aegis of the Central Vigilance Commission. Without further ado, I would like to invite Mr. Mukherjee for the session. Today, he shall be speaking on the topic of application of administrative law in the sphere of employment. Over to you, sir.
Yeah. Dipti,
Sir,
can
just a moment.
slideshow mode, please, Dipti.
Sir, it's on slideshow. Is it visible?
No, it's not coming as slideshow mode.
Okay.
Okay, Dipti, then I can take it. No issue. I will take over.
Okay, sir.
It is now you're able to view it in slideshow mode.
Yes, sir.
Yeah. A very good morning to all of you. The topic of today's session is application of administrative law in the sphere of employment. Welcome all the delegates who are present here and all the participants. Without further ado, I would start the topic on application of administrative law in the sphere of employment. Now, what is the term administrative law? What do you mean by that? It's not something which is a newly coined term. Basically, in every legal system in the world, there are traces of administrative law. Be it from the ancient times of Maurya, the Guptas, the Mughals, or even in East India Company during their regime. The term administrative law was very much present, and in fact, administrative law was not codified. It was not well documented or not well defined. It was basically an unwritten, uncodified thing, which is primarily sourced from various judicial precedents. What used to happen in ancient times, the kings and the administrators, they were in fact governed by the concept of dharma. That is what in Indian context we give huge importance to that. And the kings and their officers, they used to follow the basic principles of natural justice, and then fair play of administration that could only be run on the principles of administrative of natural justice, which was, they thought that it is well accepted by the principles of dharma. But in strict sense, if you see, there was no administrative law what is being studied at present. And in fact, during the 20th century, the administrative law had noticed the most notable development, wherein its development, the development in the sphere of administrative law, goes along with the society's development. When it comes to the sphere of employment, I need to mention that in the 20th century, it was the principles of laissez-faire which was predominantly existent there, and there it was a minimum government control, and the power was entirely concentrated in the individual hands. Now, this led to a concentration of power within individuals, and there was economic disparity, which widened the gap between the poor and the rich. Now, this kind of system actually was a debacle, and it's increasingly the economic disparity was very much evident, wherein the rich became richer and the poor become poorer. Now, in this era of laissez-faire, what happened? The industrial relations was primarily governed by the principles of master and servant relationship, wherein the concept was hire and fire. You need a person, you hire, and then you don't need, or without any citing any reason, rational, you can fire. You can discontinue the person. It was primarily referable between, you can say, a contract between unequal persons, wherein the master was predominantly having a dominant position over the servant who used to work under him. And subsequently, the developing notions of social justice which came into play, and with the expanding horizon of social economic justice, there was a necessity which was felt by all the states as well as the societal development. It was felt that statutory protections are required for this set of workmen, because they are totally an unequal partner in the industry, and they are giving their toiling their blood. They are from morning to night, they are actually working, but they are not getting adequate safety measures, the security of their job and all those. And that is how the entire industrial law and the various legislations came into force. Next slide, Dipti. Sorry. Now, once we come to this background of how the industrial law came into play, we would now dwell into the concepts of administrative law first, and thereafter we would see in the light of industrial law. When it comes to administrative law principles, you would find the concept of rule of law or due process of law. Now, exactly, the term due process of law basically is a doctrine which checks if law is there and it deprives life and personal liberty of a person. But at the same time, the due process of law also ensures that law which is made is fair and just. Now, in the rule of law or the due process of law concept, doctrine of supremacy of law, that is, law is paramount. Nobody is over and above the law. That is one of the primary notion which needs to be kept in mind when you are actually dealing with due process of law. Then comes equality before law. All are equal before law. Now, if I say this word, that equality before law, you might see in the context of, if we see in the context of employment law, it is not that all groups you need to see in one particular framework. Say, for example, a director of a company and a clerk of a company, you would not deal with them equally because they are not a homogeneous group. The equality before law actually means it has to be a homogeneous group, basis which you would see the equality, and not between groups which are not, you cannot compare with each other. Why this we are dealing with this principle? Say, for example, in parallels of service law, if the same act is, as there is a fraud, there is a financial misappropriation, and a clerk who is primarily responsible, he is guilty, found guilty in inquiry, and his supervisor, who is actually overseeing the entire activities, who has a supervisory role, he is also found guilty. Now, you cannot claim that because of the concept of equality before law, the clerk and the supervisor both should be treated at par, and for both of them the penalty should be same. That is the concept of equality before law. I would deal with this concept when I'm subsequently dealing with this in parlance of departmental inquiries. And then next comes predominance of legal spirit. That is also one of the essentials of due process of law. Now, when courts find that something is violative of the fundamental rights, they can declare them void, not only on the substantive question, that is whether the law is within the powers of the authority concerned to enact or such, but also they would see on the procedural ground that whether the law that is framed is reasonable or not. So, due process of law basically, if I say, is whether the in the legislature or the authority who is framing the law, whether they are having the powers to make the law, plus one more addition, that is what they have made, whether it is fair or just and reasonable. If not, then it actually hits the principle of due process of law. So due process of law is basically the powers of enactment, whether they have followed the entire process while enacting the thing, plus principles of natural justice. You can say all the principles, they have to be also taken care when we actually interpret the provision of due process of law. Now we have, I'm not going to play this video, but I would just give you a classic example which I thought would be appropriate in this. We have all heard about Trump's impeachment process, which happened during the recent years. Now the US Constitution, it discusses the impeachment process of a president, and that empowers in few occasions there can be impeachment of a president. It provides that the House of the Representatives shall have the power to in the impeachment, and regarding the upper chamber of Congress, it mandates that the Senate shall have the sole power to try all impeachments. And the Constitution further it mandates that the Senate would be the conducting the trial of the president, and the Chief Justice would be presiding. Chief Justice of US, he would be presiding this trial, and the conviction actually, if it is they have to impeach, then at least 2/3 of the senators need to vote against the president's removal. Now, this is the basic concept. What happened is that when the impeachment process took place, Trump's advocates, they were advocating on this particular context that their main submission was that the Chief Justice of US, he had before this entire decision was made public, when the before the process of impeachment was on, finally declared, when the process was on, he urged all the senators that they should remove Trump. Now here, the predominantly what happened, he tried to influence the senators who were voters in this entire process. So then he is actually having a biased approach towards the person against whom he is ultimately giving the decision. So the argument of Trump's counsels were this only, that this is violated by the principles of due process of law, because you have adhered to the entire process. That is, you have the powers as per the US Constitution to impeach president. You have followed the procedure. You have placed before Senate. It is presided by president. Everything is fine. Chief Justice. Everything is fine. But you basically lack the adherence of principles of natural justice, and that is how you violated the due process of law, and that is embedded in US Constitution. So the process of impeachment lacks that particular aspect. Now, when we come to the next part, that is procedure established by law. This is the other theory which is there in Indian Constitution. This is a famous quote from the Shakespeare's Merchant of Venice. Procedure established by law, you actually see this particular in the context of Article 21, where it is mentioned that no one can be deprived of life and personal liberty, save and except procedure established by law. In fact, when the Constitution was supposed to be framed, Sir Venegal, who was there, and US one judge was there who had given the advice. He in fact suggested that it should not be due process of law. It should be other than something due process of law, because due process of law is having a wider aspect. In fact, Dr. B.R. Ambedkar, who was a scholar of Columbia University, he initially in the draft he had placed in Article 21 the word due process of law. It was not procedure established by law. But subsequently, when ultimately the constitution was placed and tabled and it was adopted, it was the word came as not due process of law. It came as procedure established by law. And there was other two things which it might not be pertinent here, that the entire article was no one shall be deprived of his life, liberty, and property, save and except due process of law. That was the original article, which was subsequently changed. The liberty was qualified with the word personal, and the due process of law was changed with procedure established by law. Now, when this particular aspect was, this was the Constitution, Article 21, which was framed, what happened? The first thing which came in 1950 only, after 47, after the Indian independence and the Constitution was adopted. The first thing was A.K. Gopalan versus State of Madras, which the case which came, wherein Prevention of Detention Act, this particular provision came into force before the Honorable Supreme Court. And the Supreme Court held that the word under Article 21 actually means procedure established by law. So they interpreted it in a narrower sense, and they mentioned that since Article 21 only mentions about procedure established by law, so in that case the court would not at all get into the thing whether the law which was framed by the legislature is just, reasonable or not. It is not the duty of the court, and court restricted it to only whether the process which was followed for enacting this legislation was correct or not. But in those days, Justice Faisal Ali, he actually gave a dissenting view, and he dissented with the majority view, where he adopted a much more expansive interpretation of this phase of procedure established by law. And he had held, in fact, in that dissenting judgment, that in Article 21 the principles of natural justice are also an integral part. But somehow it was a dissenting view, so the majority view ultimately sustained. But subsequently, we found that in Maneka Gandhi's case, Maneka Gandhi, where her passport was propounded, and in that landmark judgment post-emergency, the Supreme Court ultimately interpreted this procedure established by law to be an integral part, wherein principles of natural justice, that is the procedure which is established by law, also needs to be fair, just, and reasonable, and not fanciful. This particular aspect was also incorporated and interpreted by Supreme Court in that judgment. And then if you see, there was a backdoor entry of this due process of law, what I explained earlier, in our constitution, by virtue of interpreting Article 14, 19, and 21, when they interpreted this in this judgment. So in this way, when we are dealing with subsequently the procedure established by law, would mean not only the law which is framed, or not only the rules and regulations which are there, but whether they are just, fair, and whether they are not arbitrary. So that aspect also needs to be borne in mind. When we are dealing with in the sphere of employment law, this aspect needs to be also kept in mind. Now we would go to straight away go to the various constitutional provisions which are there with regard to employment. Now the first provision which I would deal with is Article 309. Now Article 309 basically empowers the legislature to regulate the recruitment or conditions of service of the civil servants who are appointed in public services and post in the affairs of the union and the state. Now there in that same article only, it also provides that pending this kind of legislation, the president or any such person whom he is authorizing would be competent to make such service rules. So based on that, way back in 1964, the CCS rules, that is applicable to civil servants, their service rules were framed. And then subsequently the central public sector undertaking who were there, for them model conduct, discipline, appeal rules, those came into force. in 1974. And that is how the entire service rules of people who are employed in government sector, the people who are employed in public sector undertaking, those came into, and the origin of those things, you can say, is from Article 309. But let me tell you, Article 309 is restricted to only civil servants. Like, we are employees of central public sector undertaking, so we are public servant but not a government servant. These Article 309, 310, and 311, these three articles are applicable only to government servants, civil servants, and not to central public sector undertaking or state public sector undertaking. They don't get the immunity under these sections. So next we come to the next provision, that is Article 310. What is Article 310? In England, as you all are aware, that the Crown is regarded as the head of the executive, and the civil servants who are part or parcel of the executive, they are it is thought that they are all working under the Crown, and Crown has the power to terminate the services of these civil servants. It is the pleasure of the Crown basis which these civil servants actually hold their post. And in the event the Crown decides that in the interest of the public good or public for policy, a particular civil servant needs to be removed from the services or something, the civil servant cannot sue the Crown nor can seek any damages. So that is what is doctrine of pleasure, which is there incorporated in an English law. The concept was to some extent also carried forward in India when our constitution was enacted, and in that also this Article 310 is very much there. Doctrine of pleasure is there, that any civil servant would hold the post to the pleasure of president or governor. If it is a state civil servant, it being the governor, subject to, of course, some of the positions which are not coming within the doctrine of pleasure, like Chief Justice of Supreme Court or CAG head, UPSC head. They would not come within the purview of doctrine of pleasure. But doctrine of pleasure is subjected to, there is some exceptions to doctrine of pleasure, and it is subjected to Article 311. Article 311 actually, it mentions that though the civil servants hold the position by virtue of the pleasure of the president or governor, but at the same time, a civil servant, definitely you can take punitive action against a civil servant. But Article 311 gives some kind of it empowers the civil servant or a government servant, wherein it states that you cannot dismiss or remove or reduce in rank. Say, for example, you want a director to be reduced to an officer, or a manager to a mere downgrade to an officer. If you want to do those things, it has to be through an inquiry process. What that is one. And second is that the person who is appointing you, you cannot pass an order who is subordinate to the appointing authority. Suppose the appointing authority is at the level of say, for example, GM level. So you cannot an order cannot be passed by a person who is subordinate to the GM. So the minimum GM level person should pass this kind of orders. That is what the protection is there under Article 311. So Article 311 basically covers two things. One is how, that is, it must be through a fair opportunity of hearing and inquiry. That is one. And second is that it who, that is not an authority lesser than the appointing authority. These two aspects is covered under Article 311. Article 311 also had some kind of exceptions. That is, you need not hold inquiry in two cases: where a person has already been convicted of a criminal charge in a court of law. Now you might say that why this exception? Now the degree of proof in a departmental inquiry is much lower than in comparison to a criminal court. The degree of proof in a departmental inquiry is based on the concept of preponderance of probability. Preponderance of probability is something more than a suspicion. It is not a suspicion, but it is something more than a suspicion. But you cannot foolproof it. So it is less than proof beyond reasonable doubt. Whereas in criminal case, it is proof beyond reasonable doubt. So if a person is already convicted in higher parallels, that is, when the degree of proof is higher, proof beyond reasonable doubt, based on that, if he is convicted, naturally in departmental inquiry, he would be convicted only because he has already been convicted based on a higher degree of proof. So in that case, you once again need not go for an inquiry. So if a person is convicted in a criminal case in trial, so in that case you need not hold an inquiry. That is one exception. And second is when it is not reasonably practicable to hold an inquiry, the clause states that. And third is when it is in the against the interest of the state security and those reasons. Suppose raw agent and somebody who against them, if you conduct an inquiry and all, you might have to compromise with security of the state or sovereign. So in those cases it is empowered, this article has empowered that without an inquiry you can pass these kind of orders. Now the word reasonably practicable not to hold an inquiry, there lies an administrative discretion. Now there was a case wherein the person he had threatened that if the witnesses comes or the inquiry officer holds the inquiry, I would simply thrash them. Now this was the threat which was given by the charged officer. So what the government had done, without an inquiry they invoked this clause, and they told no, we would not be, it would not be possible for us to hold an inquiry because it is reasonably not practicable to hold inquiry, because he is threatening us, he is going to beat or physically assault the inquiry officer and the witnesses, so we are not in a position to hold the inquiry. This was the uh, point, and based on this, invoking this particular clause, government terminated the employee. When it went to the court ultimately saw that this particular thing is a subjective one, and unless you have proof to sustain that yes, he has given a threat, and because of those things there was an imminent danger of to those witnesses or to the inquiry officers, if you are not able to sustain that, you cannot invoke this particular clause. And that is how any administrative action would be subjected to this scrutiny of this kind of situation. If you cannot merely note down certain things without any substance, without any evidence, and try to penalize an employee, because administrative this kind of decision would be scrutinized in the eye of law. So that is how the article 311 exceptions are to be read. Now next comes is article 14. Article 14 is right to equality. I mentioned that it gives equal right to all the person who are in homogeneous group. It cannot be that the example which I gave, a clerk cannot seek and that I should be paid at par with a supervisor, because when it comes to service jurisprudence, you can say that why the salaries of two individuals are different. Article 14 is there. It is because their experiences are different, their job role is different, there are a lot many different criteria based on which their salary, perks, all those things are determined. Similarly, when it comes to a punitive action, when it comes to an penalty imposed upon an employee or an officer, this particular thing would be seen what is their exact role. Based on that, the penalty would be imposed, and not merely because that they are it is arising out of the same incident, so all should be penalized at par. So that is how article 14 to be read in the context of employment law. When it comes to article 21, life and personal liberty, I just had quoted the Shakespeare's words from Merchant of Venice. Now here, if you are dismissing an employee or you are removing an employee, basically their life to live livelihood is jeopardized. So courts are always very much critical when it comes to dismissal, removal, this kind of action. And court would see ultimately whether it is not procedure established by law, but whether you have actually followed the principles of natural justice. That is due process of law, the wider ambit of procedure established by law, which I just mentioned about the interpretation of Manka Gandhi case. So you would find that employees who are public servants, but not government servants, like central public sector undertaking employees, or employees who are state government public sector undertaking, or maybe employees who are employed under state under article 12, but they are not the government employees directly, they would invoke article 14 and 21 for safeguarding their right. they cannot come under Article 309, 310, and 311 because they are not civil servants. So these particular three articles would not protect them. But this balance two article would protect, and most of the writs which are arising out of this kind of actions, it may be promotion, it may be dismissal, it may be any other thing, action, administrative action on the part of the employer, those would be hit by these two articles, that is Article 14 and Article 21, and you need to pass on the test of these two. Now, when I come about the dimension of employment law in administrative dimension, so I need to first distinguish in these two aspects, that is public and private employment. Once it comes to private employment, normally what is seen is it is basically the contract which would be determining factor. You cannot go to straight away go to rate and then because if against private organization, mostly the rates would not lie because they are not state under Article 12. So you cannot go to rate. Yes, of course, private employment, you would get some kind of protection. Those are there under Industrial Employment Standing Orders Act 1946. That act is there. So workmen get some kind of protection under that. They can invoke those, and then they can approach tribunals and what other various machineries which are framed, but not directly go to writ jurisdiction. But when it comes to CPSU employees or state government employees or any other organization which is coming within the purview of state, they can invoke Article 226 or 32, and then they can invoke the writ jurisdiction of this court. Second comes when it is a termination simpliciter vis-a-vis a punitive action. Now, you would find that there are clauses in the standing orders also, and there is a concept of abandonment of services. Now, suppose a person is not coming for office for 2 years, 2.5 years, 3 years, and so basically you can strike off the name of the person that he has abandoned the services. But when a person is not coming for maybe 6 months, 7 months, and then without an inquiry, you simply terminate him, you simply dismiss him, remove him, that is a punitive action. So courts have held that when it is the person have abandoned, voluntarily relinquished his service, that is termination simpliciter. It doesn't cast any stigma on that particular employee. But if you are passing any punitive action, if you are passing any punitive order, it needs to be after adhering to principles of natural justice. You have to give him hearing opportunity, and thereafter only you can pass this kind of orders. Unfair labor practices. Now, when it comes to employment law, one of the foremost thing is unfair labor practices. It may be pertaining to transfer, demotion, dismissal, promotion, various aspects of employment law. Unfair labor practices have all been mentioned under Schedule 5 of Industrial Disputes Act 1947. Now, if you see basically Industrial Disputes Act 1947 under 2RA, the definition, it states that what is there mentioned in Schedule 5, those are all unfair labor practices. So, in Industrial Disputes Act under Section 2K, it defines an industrial dispute. And when it defines an industrial dispute, it mentions that dispute between this kind of industrial dispute has to be espoused by the union or a group of workmen. Now, if I violate something and do some unfair labor practices, unless I dismiss an employee, unless I remove an employee, unless I retrench employee, that is basically that unless I terminate employees, other than that, individual employee under Industrial Disputes Act cannot approach to the tribunal. Individual employee can approach to the tribunal only under Section 2A. That is the only provision which is there under Industrial Disputes Act. So what about other unfair labor practices? If suppose I have been transferred, management had taken some malafide vengeance against me and had transferred me from one place to another. Where do I go? So because as such, it cannot be an industrial dispute unless the union espouses the cause. So for workmen, even in those cases, if the person is in public employment, he can straight away invoke the writ jurisdiction in those cases where those are not industrial dispute per se, and dispute cannot be raised because 2A would not empower a workman individually to go for with regard to a dispute pertaining to his suspension or transfer or promotion, these kind of things. So the ultimately, if you see, though there are provisions under Article 323A and B of administrative tribunals and all, these tribunals are there, but tribunals, despite this, with the limited scope of their jurisdiction, these kind of things ultimately would be, has to be invoked through writ jurisdiction only. So the writ courts again are saddled with this aspect of determining unfair labor practices when it is not a pure dismissal or termination. But again, comes when it is unfair labor practices, the administrative decision, the courts would actually see whether you have followed principles of natural justice, whether your action is fair, just, and it is there is rational behind doing that. If you see in a recent case of MP Madhya Pradesh, one of the lady judge, she was transferred to a remote location because she has made some complaint, and the matter went up to Supreme Court. She challenged her transfer order. The Supreme Court held, when you have a specific policy for transfer, and that particular lady, she was having her daughter who was appearing for the board exams, and then when you transfer her to a remote location, it means you are victimizing. So when the rules are there, when the policy is there, any administrative decision with regard to employment needs to be in the four corners of that particular policy. If you are going outside the policy, you need to record the decisions, otherwise it would be treated as a malafide. Various labor laws which are there, I have already mentioned those. Now under labor laws also, you can take lot many administrative jurisdiction, are discretion are there. Say for example, you file a case under Gratuity Act, the labor authority who is the empowered to adjudicate, he is also having some kind of administrative powers with him. There are conciliating authorities, they are also having. So under those laws, various powers are there, but whatever you are using, it needs to be based on fair play and transparency. Then comes tribunals and writ courts, which are empowered to adjudicate these matters. Separate for administrative tribunals, central government, state government, CAT, SAT, those are there. For industrial cases, industrial tribunals are there, labor courts are there, which actually deals with this kind of aspects, industrial disputes and any other unfair labor practices, all those things which I mentioned. Apart from that, writ courts are also there, which adjudicates this matter. Now, what are the scope of judicial review in administrative actions? See, first is if the order or the decision what is being passed, whether it suffers from any illegality, whether there is the order is rational, whether any reasonable prudent person in similar circumstances would have taken such kind of decision. So it has to pass that test, Wednesbury test. You say there can be two things. One is this test of proportionality. Say for example, a security guard, he is sleeping on duty, and a clerk sleeping on duty. Under the principles, if you see, yes, your service rules permits you to impose a penalty of dismissal or removal. But whether for a clerk sleeping on duty, whether you would dismiss him, the answer to this question would be no. Because if you simply for one instance, if you have seen him sleeping on duty, if you terminate the services, it would mean you have taken a shockingly disproportionate decision. But when it comes to a security is supposed to be agile at all times, because if security is compromised, then the entire particular location of the establishment, security and surveillance is at stake. So for single instance also, this kind of action, misconduct, if it is proved, you can think of taking action, maybe termination also. Courts would definitely, if you give proper reason, courts would uphold that. Finance clerk guilty of misappropriation of fraud, now there the organization or the company would lose confidence on that person. But the same might not be applicable for a person who is not upon whom so much faith is not reposed. Maybe he is only a stenographer, So stenographer doing some kind of hera fairy, say for example fraud and something, you cannot simply on one go terminate, because those would be seen what is the role and responsibility of the individual employee. And next comes procedural fairness, how you have actually dealt with the entire case, whether you have given hearing opportunity. Those procedural fairness would also be seen in the light of when it is scrutinized in the by adjudicating court. Now, when it comes to procedural fairness, you need to follow the principles of natural justice, which is no one shall be condemned unheard. You have to give hearing opportunity. The next is you cannot be judge of your own case. Suppose I am the witness, I cannot be the inquiry officer or the disciplinary authority uh, or the competent authority imposing the penalty. And last is the order needs to be a speaking order. Now when we speak about tell about speaking order, I always tell about 4 C's. What are the 4 C's? 4 C is, first C is the context of the case. Your order should always contain the context of the case. Second is content, what are the various contentions, what are the contentions of both the parties, you need to accordingly deal with that, you need to mention that. And then comes consideration. Based on the what are their contentions, you would consider whether they have a valid contention or their contentions are not correct, those are afterthought, or those are not devoid of any merit. And based on that, the consideration, you would ultimately reach to a conclusion. So 4 C's would make your entire order as a speaking order. If 1 C is missing, then your order lacks to be a speaking order. There was a case of Calcutta High Court only, that was a case of Coal India. What happened? There were 6 paragraphs in the order. The first 2 paragraphs dealt about what was the charges against an employee. The third paragraph dealt about the employee denying the charges. The fourth paragraph straight away deals with that the disciplinary authority found that the charges are proved and then imposed a penalty. And the fifth and sixth paragraph dealt with the how the order would be implemented and then the appeal provision. Now in that case, when it went to Calcutta High Court found that yes, context was there, that there was a charge sheet and all those things. Contentions, yes, charge sheet, what are the charges you have mentioned, the reply you have mentioned, so contentions are there. Consideration was lacking because you only said that the reply was not found to be satisfactory, but on what grounds that consideration was aspect was missing. And conclusion, yes, you have imposed a penalty, so conclusion was also there. So 3C was there, 1C was missing, and the order was straight away set aside. Just to give a simple example of how to make the order a speaking order. Now, I have tried to attempted to give a summary of how the disciplinary action process is. I would not take much time because I have to deal with your queries. Within 2-3 minutes, I would deal with that. Initially, a complaint comes, whatever be the complaint, irregularity, that complaint would be investigated. Based on that, there would be a decision by the disciplinary authority to take a disciplinary action. Once he decides, he would issue a charge sheet. Charge sheet would contain each and every allegation, and it is basically like in IPC and all, you link that in a charge sheet. In criminal law parlance, you actually link what are the IPC section they are violated and all. Here you would link with the service rules, what are the misconduct he has committed in light of the service rules. Based on that, the employee would give a reply in light of this charge sheet. And if the reply is not satisfactory, it would go for a departmental inquiry. Now, departmental inquiry, in that case, first the prosecution, that is the management, would lead their side. They would give their evidences, their witnesses, their documents. Witnesses would be cross-examined by the other side. And then the defense case, defense witnesses would be also cross-examined. And then after the prosecution case and the defense case, the summation reports is nothing but written arguments of both the sides. First, the management side would give their written argument, followed by defense argument. And then based on that, the inquiry officer would submit his inquiry officer's report, whether the charges are established or not. Inquiry officer would only restrict to that. He would not say anything about penalty, what penalty to be imposed. Once the inquiry officer's report is submitted, the report would be forwarded to the charged employee. Now here, this is a critical portion, because in criminal case, if you have seen, after the charges are proved, the court gives an opportunity of hearing with regard to the sentences. What is the sentence which would be imposed upon an accused? Here, this is nothing but this second show cause notice is that only, that you get the inquiry officer's report and say you have the observations that yes, all the charges are proved. Whatever you want to say, you say here. But there would not be any personal hearing in this particular aspect. Only the inquiry officer's report would be forwarded. Based on that, the say can be given, and then based on the say, the final order of the disciplinary authority would be passed. If the order, if a person is aggrieved by the order, he can prefer an appeal. If in certain service rules there are provisions for review also against the appellate authority order, and after that, after review, if you are not at all satisfied, then you can go for adjudication, what we referred to in the earlier slides. So this is how the entire gamut of administrative law in employment sphere, this is how the entire process runs. And the main and the ultimate thing what you need to be very careful about is the reasonableness, rationality of the decision, and the proportionality, that is a part of rationality only, where your action needs to be reasonable, and it should, if it is scrutinized in the eye of law, it should be that any prudent person would have also taken this kind of, see, there can be that two options, that either this way or that way, but both are correct. In that case, if you take one side and you don't take the other side, it's fine. But if you take, when the option is only one, and if you take the option which of the reverse other side, then it is shockingly disproportionate, because then normal prudent person would not have actually taken that kind of decision, and court would strike down those kind of decisions. This is how the entire interpretation to be made. That's all. Any queries, you can, questions, you can.
Yes, sir. Thank you so much for that very enlightening session. I would like to read out the questions for you, sir, which have been posted in the chat box. So the first question is asked by Mr. Shavik Ghosh. He asks, if an employee is dismissed from service because of suppression of higher qualification, when the service regulations require lower qualifications, which is treated as major misconduct, can such an employee get protection from a writ court under the expanding horizon of Part 3 of the Constitution?
Okay. See, Shobik, first of all, if the minimal qualification is already having, but he has suppressed what is higher qualification. Now, there, the clause is anything, if you hide garment to your employment, definitely the action can be taken. But interpretation can be here. Reason, again, I go to the words, what a reasonable, prudent person would have taken. Suppose I require a safai wala, and the safai wala is MA. So anyhow, he can do safai. He met my minimal requirement. So if I terminate him for hiding that particular thing, if he would not, actually, if he would have told that I am an MA, would it prevent him to appear for that, qualify for that particular thing? The answer is no. But yes, when it comes to an interview and all those things, the interviewing board might have thought he's too much qualified, so he's not fit for the safai wala's job. So it can be, in this case, I can interpret in either way. But at the same time, courts have been very there are 2-3 judgments. I am giving you an example wherein a person has hidden his previous past criminal record. Ultimately he was acquitted, but he had hidden that fact. Court told it is immaterial whether you were acquitted or not, but you were supposed to diligently provide those information. Since you have not provided, the employer is correct in dismissing the employee. So if I take that kind of citation as a precedent and then cite in your case, if I terminate, then the employee might not have any say. So it is always prudent to disclose proper things. But if not, the employer can take decision. Yes, he has hidden which is garment to the employment, and then terminate. He would not get any protection, provided I follow all the inquiry procedure which I just narrated in that particular slide, that give hearing opportunity adequately. The principles of natural justice part has to be adhered to in true sense.
Thank you, sir.
Yeah.
So the second question that we have is, are the accusations true that organizational administrative structure has been so complicatedly constructed that it comes in the way of effective administration or matters, and the factor of necessity has been completely ignored the way it has been constructed?
it may not be true because see for depending on the organizational hierarchy and the size of the organization, they make this kind of structure. Today, like I am telling you, in HPCL we have for workmen, we have online system wherein they give they raise their grievances, and it comes to the location level, then to the zonal level for redressing their grievances. When it comes to officers, we know that even they can allege against their bosses or against their supervisors, so it would not be prudent that we deal with their supervisors. So we have a mechanism wherein those kind of things comes before a grievance redressal committee at top level. So there are channels, and depend, see, if it's a organization of 10, 12, 15 or 20, it's very easy to handle. But when it comes to an organization of 10,000, 20,000, 50,000, your grievances you cannot channelize like that. It has to be some kind of flexibility, and complexity has to be there depending on your organizational structure, so that one person or the decision making thing is not vested in one or two individuals, but it is percolated down based on the hierarchy of the organization.
Sir, so just I have a short follow up to that. So there's a judgment by Justice Chelameshwar, wherein he says it's not about whether there is corruption in the organization or not. It's about whether there is the power to do corruption. So whether the framework itself allows for it. So, sir, we've often heard of urban legends wherein IAS officers, I think Officer Ashok Khemka and all such people have been transferred about 54 to 55 times. So, sir, is there a mess up with regards to the entire transfer policy itself, or higher individuals using loopholes which are given in the policy? So, is there a policy making issue, or is there an execution issue there?
See, I mentioned about the doctrine of pleasure. I think it perfectly fits, because this kind of things, when if you see in US, they follow this particular aspect. The government changes, the entire hierarchy changes. In India, luckily, we do not have, even if it is whether UPA or BJP or NDA or anybody, when the new government takes over, the entire set of people who are there, they are not changed. Only their loyalty might shift because the bosses, the ministers and all, they are changed. Now what happens where in the scenario of Indian perspective, the examples what you gave, people are there who are whistleblowers, and there has been always an attempt to maybe to victimize them in some way or other because of various reasons, extraneous reasons, which I do not want to quote in this forum. But of course, there are policy, particularly in organizational setup, when it is coming to corporate governance. Under Companies Act, also you have clear guidance of framing whistleblower policy. Even for government organization, central PSU or state PSU, or state government or central government, you have a watchdog, which is CVC, Central Vigilance Commission, and whistleblower complaints can be given to them wherein you don't disclose your name, your particulars, and all, your entire those things you have to disclose, but they would not disclose. They would keep it, they would suppress it, and then forward those complaints for proper investigation. Now, in today's scenario, CVC is also saddled with more than 20,000 plus complaints, and then they do not have so much manpower. You cannot now, for every small cases, you see that CVC is people are telling go for a CBI inquiry. It is CBI is also almost 60% of the CBI functional are deputationist. So their manpower also, there is a challenge for them also to get into each and every. There is a murder, the people would tell go for investigation. Now I understand murder like Arushi, yes, CBI goes for an investigation, but here in every place wherein there is a murder, something is suspicious, now people do not have the faith on ACB or something. Everything has to go to CBI. So in this kind of scenario wherein with our structure and with the population and corruption at every sphere of life, you cannot get into investigation at every stage, and that too by a competent authority. The entire thing depends on who is investigating and how they are investigating. And of course, in conduct rules, whatever you say for government, for PSU employees and all, there are adequate protections. If a person is corrupt, he can be terminated, his services can be discontinued. But only thing is that I told with regard to parallels of administrative law, you must have proof for that. You need to provide adequate documents or oral evidence to substantiate those things. Now witness turns hostile when it comes to inquiry. The same land mafia cases and all, the people are afraid, they are scared to come. We had a case wherein you might have all heard about when you were in 10th or 12th standard, I think, IOC Manjunath case. With regard to a racket of petrol, adulteration of petrol and diesel, and that person was there, he was murdered, brutally murdered. Now you can, with a CBI inquiry and all, you cannot get the person back, right? Only thing, and who would tell that yes, we have seen him murdering? Because when it comes to UP, Bihar, or any other place, you say that, then mafia group again would come. And it is not only UP, Bihar, it is across India, where adulteration in petrol pumps have been at large scale at various places, and lot many people were involved. There were cases, there were investigations, CBI cases were there. So it is going on, but definitely I can say that with transparency, RTI Act, various things are coming into fore. Maybe in next generation can see that it is drastically in reducing scale, not in the scale which used to happen earlier. It used to happen, we never used to know that, but today things are coming in fore. All of us are at least privy to those things, like NSE, that CEO, the immediately those things, see, she had retired in a span of 13 to 15, and within that that Yogi Baba, whatever, she had sent the emails and all, today those things are in public light. Can you think of those things 20 years before, 2 decades before? So definitely we are going in a direction. It would take some, we cannot expect ours to be at par with US or UK, but it would take some time. But definitely we are I'm telling you, when we had studied law, that time, in fact, law was not seen as a profession. It was a profession of only if you have your dadaji or father, and hereditary, it would pass on. But today all of you are in premier schools, and people choose law as a profession. And the law is such a stream that this prevention and all, this whatever corruption and all those things, you can prevent by virtue of a strong judiciary and a mechanism wherein we play a key role, pivotal role in changing the society in this.
Thank you so much, sir, for that lovely and astute answer. We actually have two more questions, but due to the paucity of time, I don't think we'll be able to take it. So I'll move on to the vote of thanks. So I would like to humbly take this opportunity to thank sir on behalf of each and every one of us. It was a very, very interesting and intellectually stimulating session. Thank you so much, sir, for sharing your wisdom with us and for answering our questions. I would also like to thank the participants and the team for organizing such a interesting session. I shall now hand over this virtual dais to the next moderator for the next session. Thank you so much.
Thank you. With your permission, I would log out.
Yes, sir, definitely. So thank you so much, sir.
Thank you.
Good morning, everyone. I am Vala Shrita, and I will be your moderator for this session. The second session today will be on testing the limits of administrative actions in India and charting out its implications. For this session, we have with us today the eminent speaker, Professor Farah Ahmed ma'am, and also Balu Nair sir. Farah Ahmed ma'am has joined Melbourne Law School in July 2012. Before joining Melbourne Law School, she was a lecturer in law at Queen's College, University of Oxford. Her education history includes LLB from University of Delhi, Bachelor's of Civil Law and MPhil in Law, and Doctorate in Law from University of Oxford. Ma'am's recent work include constitutional statutes, religious freedom, doctrine of legitimate expectations and duty to give reasons, and religious tribunals has been published in Cambridge Law Journal and Modern Law Review, and also Oxford Journal of Legal Studies. Her recent book, Religious Freedom Under the Personal Law System, was published by Oxford University in 2016. Ma'am is also a founding editor of Indian Law Review and Admin Law blog. She serves as an associate director and Asian Law Center, Melbourne Law School. It's an honor to have you here, ma'am. We also have with us Balu Nair sir. Sir is an assistant professor at the Jindal Global Law School and is also a research fellow at the Melbourne Law School. Sir is also a graduate and alumni of NUJS of class 2014. So he's worked with AK Law Chambers, Cyril Amarchand, and then at IDI before enrolling at the Melbourne Law School. And he's also an scholar of Alex Chernoff. Sir is interested in range of public law issues, and his recent research focus on federal asymmetric government liability for publicly held data and horizontal application of fundamental rights. He's particularly interested in interface between private and public law. It's an honor to have you here, ma'am and sir. The floor is all yours.
Thank you so much. Can you hear me okay? Okay, thank you so much for that really, really kind, really generous introduction. And thank you so much, I think, speaking on behalf of Balu as well, for having us. I think we're both really happy to see this entire conference on administrative law. It's very, very rare to see an entire conference on administrative law. It's such a under-researched area of law. I think it's an area of law that's so vitally important, but that gets so little attention. So I'm just so pleased, and thank you particularly Professor Chengappa for inviting us. We're very, very grateful to be a part of this really fantastic conversation. So I want to begin in a way that's traditional here in Australia, by acknowledging that I'm joining you from Melbourne, yes, but also from the traditional lands of the Wurundjeri people of the Kulin Nation. They are the indigenous peoples who have been the custodians of these lands for over 60,000 years. And so I want to pay my respects to them as well. So Balu and I, as we heard already, we're going to talk about the limits of administrative action, the scope of administrative law. And we're going to do that in general terms, but at points it becomes quite useful to think about the scope of administrative action, the limits of administrative law, with respect to a example. And so in those kinds of situations, we're going to call on citizenship jurisprudence around citizenship and immigration, because that's an area of law where you often hear arguments that, oh, this is outside the limits of administrative law. That is, courts and judges cannot interfere with this administrative action. So we're going to appeal to that example whenever we think an example is useful. So we're gonna talk about a couple of things today. So I thought it might be useful to take you through our plan for the talk. And let me just try to share my screen here. Yeah, can you see that okay? Yeah, is that working? Oh, good. Okay, fantastic. Okay, so we want to talk about, first of all, Balu will talk about the scope of administrative action in general terms. That is to say, is as a general matter, what can administrators do? That is, what can the executive do and what can other administrators do? So once we hear about that from Balu, then I want to say a bit about the scope of judicial review. That is, when can courts interfere in administrative action via judicial review? And this will be familiar to some of you, but essentially I want to talk about the grounds of judicial review, the rules or the principles based on which courts can interfere with administrative action. We're then going to think about, because the other side of the scope of administrative law or the scope of administrative action is the question of whether there are aspects of administrative action, whether there are types of administrative action that are completely immune from judicial review. So maybe in theory, courts can interfere on these on a range of grounds, but are there certain areas like citizenship, immigration, national security, and so on, where courts cannot interfere at all, where judicial review is not available at all? This has been suggested recently, but so we want to explore that. I'll then hand back to Balu to talk about deference and whether, even if courts can interfere in those kinds of areas, are they then more deferential when they deal with certain topics, and how deferential are courts over administrative action more generally? And we might wrap up just with some suggestions, some thoughts on possible ways to see whether we can offer better accountability over administrative action. So with that, Balu, I'll hand over to you, and I'm happy to move through the slides as you talk.
Thank you so much, Farah. And I want to echo everything that Farah just said, that, it's great to see that there's a full 2-day conference, conclave, organized on administrative law, which is not a commonplace occurrence really in India. So it's a great initiative, and I'm extremely delighted and I'm thankful to the organizers for having me here today. And again, it's a privilege. Chenkappa sir taught me administrative law in NUJS, and that makes the occasion even more special for me. So yeah, without much ado, I'll just straight away jump into the presentation. So I think when we discuss the scope of administrative action in India, it is difficult to look past the locus classicus, which is the Ramjavai Kapoor decision. Although the decision came way back in the 1950s, it is a very commonly cited, used judgment in the curriculum in all law schools in India. Now, Ramjavai Kapoor sort of sets out the broad scope of what actions can be taken by the administrators and the executive in general. So instead of giving like an exhaustive list of things which they can do, what they instead did was to say, look, whatever is the residue of the functions which are left after you exhaust the judicial functions and legislative functions, those are the executive functions. And you cannot really fault the government, the judiciary, for doing that because of the broad scope of administrative powers. And they, in fact, place emphasis on the fact that executive or administrative powers is not just about executing laws, it's much more than that. So, throughout the judgment, you will see that the court was very careful not to close out the options for the administration. And, in a way, that has done well, because as the regulatory state sort of takes over more and more spheres, the open-ended definition has enabled them to act within the scope of their powers because of the way in which the court defined it there. Now, one other important takeaway from the judgment is that you don't necessarily need to have a specific legislation which sets out that these are the powers which are there with the administration. So as long as the executive is competent, and when I say the executive is competent, I mean that as long as the executive, say the union, the powers it is they are implementing, it is coterminous with their legislative competence, it's perfectly fine. Similarly, for states, as long as the powers that they are exercising, they are coterminous with their legislative competence, it is fine. You don't need a specific legislation saying, look, you have the power to carry on trade and commerce in the sphere of, say, transportation, for instance, right? As long as it is within their general legislative competence, that's all well and good. The only kind of exception they carved out here is in when it comes to appropriation of fund. So if there is any kind of appropriation of fund, there should be at least an appropriation act which should be there. So even if there is not a specific legislation saying, look, the legislature is empowering the executive to withdraw funds for the purpose of running, transportation business or whatever. Even if that kind of a specific legislation is not there, as long as there is a general appropriation act, that's fine. But when it comes to expenditures like this, the court said you need a specific appropriation act at least. So this is a way in which the court set out the powers. Just to recap, as long as they are competent to enact laws, that's also a sphere where they are competent to take administrative action. And in case it involves expenditure of funds, that would require an appropriation act, right? So moving on, they also laid down a few limits to what the administration can do after setting out this broad-based scope of administrative powers. One thing which Farah will be speaking to in great more detail, and I noticed that our previous speaker also was alluding to a number of these limits, which is that administration can never go against any law or the provisions of the Constitution. Now, what exactly are these limits within the Constitution, as we know, is a gray area within the Indian constitutional and administrative law jurisprudence. and that is something which Farah will be speaking to, as I said, in greater detail. Uh, Again, the only other sort of limit which the court mentioned was that there should be the legislature's intervention should be there when it comes to appropriation of fund. There's another point which the court makes, which kind of makes things a little unclear, and I don't see any discussion anywhere on this. After saying that as long as they are competent to enact laws, they don't need specific legislation, the court also goes on to add that in case this is a fairly new area where you can't find any kind of legislation discussing these kind of powers, then you might need a specific legislation. If you're, I don't know, starting a new business or a new venture with regard to a futuristic or modern technology, which you can't possibly sort of locate within in any of the three lists within Schedule 7, then perhaps you will need a specific legislation. Now, given all the discussion we have had with respect to the residuary powers of the union, etc., I'm not sure whether this really is required, because if there is a doubt or if it is not clear as to who this power will go to, perhaps it may be covered under the residuary powers of the union. But anyway, the court added this caveat, which kind of it did not elaborate on it any further, and kind of made things a little more confusing than perhaps it needed to have done. And finally, before I hand it back to Farah, I think one of the less discussed issues with the Ramjavai Kapoor decision. Ramjavai Kapoor, I don't again see it being critically discussed anywhere. But one thing I felt is that it kind of doesn't give enough importance to the legislative deliberation aspect of things, right? And we know that of late, especially, parliamentary committees absolutely have very little time to go over many of the leave alone administrative actions. Even legislations are barely now sent to select parliamentary committees and deliberated upon. So the fact that there doesn't need to be a specific legislative backing, and the fact that parliamentary committees are becoming more and more redundant, and the fact that generally also the parliamentary discourse and deliberation is kind of coming down, I would be a little skeptical with the way in which the Ramjavai Kapoor's sort of relevance is there today. And perhaps we need to think a little more about ensuring that some of these actions are discussed at more length within our within our legislatures. With that, I will hand it back to Farah to discuss the grounds of review. Then I'll take it back on from the point of deference.
Okay, thanks so much, Balu. So yeah, so if we think about the grounds of judicial review, so if we're thinking about the scope of administrative law, then we need to know, well, okay, on what grounds, on what bases can the court actually interfere with administrative action, right? And I kind of think about the different bases on which the court can interfere with administrative action as having two sources. First of all, you've got the constitutional grounds on which the court can interfere and say, okay, this administrative action is unlawful because it breaches the Constitution. But there are also, and I think this point is really forgotten these days in our jurisprudence, there are also still common law grounds of review of administrative action which can be used by courts to interfere with what administrators are doing. And there is, of course, a great deal of overlap between the constitutional grounds of review as well as the common law grounds for review. So I just want to talk through these a little bit. So I think we're all familiar with the importance of Article 14 for administrative law. And I think many of us will be familiar with the P. Roypa case and the fact that that case basically says that Article 14 includes protections not just from administrative action, from state action that breaches equality understood in the normal sense, but also to protections from arbitrary state action, right? So basically, if the court can say that an administrator was acting arbitrarily arbitrarily, they took a decision that was arbitrary, they can then strike that decision down. They can then declare it to be unlawful. Now, one question that has, I think, never been satisfactorily settled by the court is, what do we mean by arbitrariness? When is action arbitrary, right? And courts have themselves said something to that effect. You see language in the jurisprudence to the effect of, okay, it's not always easy to see, but we know it when we see it. That kind of suggestion is in the case law. Now, I have tried to grapple with this question in a paper in the Indian Law Review, and my own view is that the best way to understand arbitrariness is it's about an attitude, or it's about an attitude that the decision maker has, essentially. And that attitude is that the decision maker is basically indifferent to the reasons that are that support or don't support a particular decision. That is to say, they are not really interested in making a decision based on the actual true reasons that should form the basis for that decision one way or the other, right? So one way, okay, and this we see examples sometimes of arbitrariness, where people think about arbitrariness and you think about people who are acting at their whim and fancy, right? And you hear this kind of language that you're acting at your whim and fancy. And examples of this might be you're deciding by rolling the dice. I mean, that may not happen very often, but it might be that you have an administrator who is looking at a file with different arguments for building a dam, and some arguments for, some arguments against. Instead of applying their mind and thinking, okay, should we actually build this dam, they just pick one side at random, or they just pick one argument at random, and they say, okay, yeah, we're going to go with this side, and we're going to pick this reason, and we're just going to go with it, right? So that kind of indifference to the reasons that should be taken into account in making a decision, that I think is one form of arbitrariness. And another form of arbitrariness, I think, is it's not that the administrator is indifferent, but the administrator rather knows that, okay, these are the reasons that apply to this decision. I should be taking these reasons into account. I should be reading this file and evaluating these reasons and then deciding based on the balance of these reasons. But the decision maker has some other motive, some other ulterior motive for deciding in a particular way. For instance, they were bribed, right? So the reason they're deciding one way is not because there are reasons to support that, but because they were bribed, right? So that is also a form of arbitrariness. And both of these really speak to the state of mind of the decision maker. That is to say, it's basically what is going wrong when you say that something is arbitrary is that the decision maker does not have the right attitude towards their job of deciding according to the reasons, right? And that's quite important to me to frame it in that way, because we have to distinguish arbitrariness from mistakes, right? Administrators are always going to make mistakes. It is, in my view, not the job of the courts to interfere when they think administrators have made mistakes. So even if the court thinks, okay, the administrator has thought about all the reasons, they have weighed them correctly, they have balanced them against each other, and they have made a mistake in what the result of that, right? If it is an honest, bona fide mistake, then I don't think the court is entitled to step in. So this idea of arbitrariness must be different from the idea of a mistake. And that is what, at least my account of arbitrariness tries to do. It tries to explain arbitrariness in a way that allows the court to interfere on the basis of arbitrariness, but not just whenever the court thinks that administrators have made a mistake, because otherwise there will be no discretion for administrators, right? It will just be about the court being able to step in and second guess anything that an administrator can do. Okay, so if we think about the constitutional grounds, one constitutional ground is review on the basis of Article 14, but another constitutional ground, which will be familiar to many of you, it relates to the doctrine of excessive delegation, right? So, according to the doctrine of excessive delegation, essential legislative functions cannot be delegated by the executive to the by the legislature to the executive, right? So the executive is only allowed to fill in the details of legislative policy. So again, so if you see executive action, if you see power being exercised by the executive, by the administration, which is not confined by some kind of legislative policy, then this becomes vulnerable to being struck down based on the doctrine of excessive delegation. Yeah. Okay, so those were the constitutional law grounds, and I think everyone's very familiar with them. But there's actually other common law grounds of judicial review, and I realize that this is quite small, but I'm happy to send through bigger notes later if that's useful. And these other common law grounds of judicial review, they are found in the common law. So they are found in, so other common law jurisdictions also have these grounds, and they are not necessarily based in the Constitution. That is to say, a court can interfere with administrative action. It can strike it down as illegal, unlawful, based on these grounds, even without invoking the Constitution. Now, some of these grounds hopefully will be familiar to at least some of you. I mean, there's the very basic principle of ultra vires, that is, the administrator is acting out of the power, outside the power granted to them by statute, or relevant consideration, that is, that an administrator has taken into account something that they should not have taken into account, or they didn't take into account something that they should have taken into account in making their decision, or they acted with the wrong purpose. They were acting in a way, they were using their powers in a way that didn't further the purpose of the legislation, right? And then there are the grounds that are related often to natural justice. That is, they have to give people who are affected a hearing, they have to not be biased, and they have to act reasonably. I mean, of course, Wensbury unreasonableness, many of you will be familiar with that standard. And more recently, we've started to talk about legitimate expectations. That is, if you're an administrator, you have to, and you have made a promise, or you have a particular practice, or you have a particular policy, you cannot just change your mind, or you cannot just dishonor your promise. You have to honor the promise. And if you want to make changes to policy, it's not that you can't, but you have to give notice, and you have to provide some other procedural safeguards for people who are affected by the change that you're going to make. And then there are the common law grounds relating to retaining discretion. That is to say, you are an administrator and you have certain discretion. You cannot delegate your powers further, right? That is the delegatus non-delegare rule. So you should not delegate your powers further. And as an administrator, you have to retain your discretion. That is, you cannot bind yourself to follow a policy in a very inflexible way. You always have to retain your discretion and make sure that you can in fact change your mind. You can make exceptions for the truly exceptional case. So that much is hopefully, at least for some of you, familiar, that the scope of administrative law is confined to courts being able to intervene on either these common law grounds or the constitutional grounds that I mentioned. And like I said, there is in fact overlap between these two. Now, when we think about the scope of administrative law, the limits of administrative action, though, we've seen, this is not new exactly, but we've seen it maybe more in recent years, that the state, the government, is making arguments to the effect that there are certain decisions that they're making, certain actions that they undertake, which are actually immune completely from judicial review, right? So they're suggesting, even if the administrator is acting in breach of those grounds that I just talked about, that they are acting arbitrarily, they are acting ultra vires, they are acting unreasonably, or they are acting in breach of legitimate expectations, or they are acting out of excessive delegation, whatever grounds that there usually are for administrative law, if it is about certain subject matters, then the courts cannot interfere, right? So the administrator is immune from judicial review is the suggestion that is being made, right? And the two kinds of arguments that Balu and I have seen recently in our the research that we're doing on citizenship and immigration is the two kinds of arguments are there's a suggestion from government that courts cannot interfere in what they are doing because they are exercising what they are calling plenary powers. Okay, that's one kind of argument that's being made. And another kind of argument is coming from the judicial language, where again the government is claiming, look, you cannot interfere here, whatever we are doing, because our powers in this area of immigration or of citizenship are absolute and unfettered. Right. So these are the two kinds of arguments we're seeing coming from the government, and I think accepted by a lot of our legal colleagues as well, as having some basis, at least in fact. Right. So Balu and I want to think about whether it's actually true that there are some kinds of administrative action that are immune from judicial review. So I want to take first this plenary power argument, because like I said, we've seen that really relied on quite recently. So in the recent CAA petition, the government's counter affidavit before the Supreme Court said, and I have a big block of text there because they really gave a lot of attention to this idea. They really put a lot of stress on this idea of plenary powers. So the government's affidavit says the question of entitlement and conferment of citizenship and issues related thereto are within the plenary domain of the competent legislature. By the very nature of the question regarding citizenship of the country and issues pertaining thereto, the said subject matter may not be within the scope of judicial review and may not be justiciable. It's submitted that such decisions are the result of parliamentary legislative policy based upon the executive, foreign policy decision making, for which constitutional courts may not have the requisite expertise to examine the parameters based on which the legislative policy is enacted. It's further submitted that the inclusion of one particular country in the list and non-inclusions of others in the CAA cannot be the subject matter of judicial review. It's submitted that if such an exercise is treated to be a part of judicial review, it will not only be an unending process, but will render all legislative classifications ultra vires, right? So there's a suggestion here, not just of, yes, there is a suggestion of the legislature having plenary powers and whatever decision they're making being subject to judicial review. But there's also a suggestion that the executive, when acting on these matters, is also immunized from judicial review. Okay, so what merit, if any, is there for that suggestion that there are these areas, some national security, citizenship, immigration, and so on, where the government has these plenary powers which courts cannot question in any way? What is the merit of this suggestion, right? Now, what we wanted to do, Balu and I, because the government hasn't really defended this position very well. They haven't really said clearly why asserting this so-called plenary power means that the courts cannot interfere. So what we tried to do is we wanted to think about what is the best set of arguments that we can come up with in defense of the government's position, because I think that's always the best way to argue, is not to decide which side is right, but rather give both sides the absolute best effort you can in building their arguments. So with that in mind, we really set to work trying to think, okay, what could possibly justify what the government is saying here, right? So maybe one thing they're saying is that these decisions are immune from judicial review because they are exercises of something like prerogative powers, or what the affidavit does use this language of reasons of the state. And as Balu pointed out to me when we first started talking about this, there is this plenary powers discussion in US case law, which is a little bit like prerogative powers. So maybe it has something to do with that. Maybe they are appealing to these kinds of powers, prerogative powers, reasons of the state, and plenary powers, right? And there is something to that, because when we talk about reason of state, when people talk about reason of state, they talk about prerogative powers. Prerogative powers are powers that in common law jurisdictions were traditionally conceived as being exercised by the crown. So there was this idea in legal theory that prerogative powers could not be reviewed. So they were powers exercised by the queen or the king, and the queen or the king, acting as the crown, can do no wrong in that kind of legal theory of the common law. And since the king or queen can do no wrong when they're acting as the crown, there's no question of the court stepping in and reviewing these powers, right? So that is as a matter of legal history how at least some people understood prerogative powers or reasons of the state. And so maybe the government is saying we have similar powers here now in India over these matters, right? Okay. But there are two problems with this position. First of all, we have not found any evidence that Indian jurisprudence has ever incorporated either the US plenary power doctrine or the doctrine of prerogative powers in England and Wales. So even if we take it to be the case that in the UK prerogative powers cannot be reviewed, or there are other common law jurisdictions where prerogative powers cannot be reviewed, we have never seen anything that suggested that that is the position in India. In fact, we have clear statements in important cases that say the opposite, right? So that's the first problem with this position of the government. And if we look at the cases, we'll see that what the cases actually say is that when you're talking about plenary powers in the Indian context, this refers to the power of the legislature to enact a law within its competence. That is to say, it has the power to enact a law according to the lists in the constitution, but that's not to say that that law becomes thereby immunized from judicial review. It's still subject to the limitations set by the constitution. And you have very clear statements in these two cases that we're citing, where the court says possessing a plenary power in this sense does not imply that the resulting legislation is immune from judicial review, right? So even on the best construction of the government's argument, we don't think it can be justified to say that plenary powers, by virtue of being plenary powers, cannot be reviewed. Okay. There's another problem though. Even if you put aside this fact that Indian courts have never accepted the existence of prerogative or plenary powers in that sense in India, the other problem is that old idea that prerogative powers and plenary powers cannot be reviewed is not the contemporary position either in the UK or in the US. So in the contemporary English position is very much the case that prerogative powers are reviewable, and they're reviewable on more or less the same grounds as other kinds of powers, other statutory powers exercised by administrators are reviewable. And US courts too have started saying that plenary powers are subject to important constitutional limitations, right? So even if you want to argue and you're unwilling to accept that these kinds of powers are not in Indian jurisprudence, if you are actually appealing to these foreign precedents, then the foreign precedents have to be correctly understood. And those foreign precedents do not imply that these kinds of powers are not subject to review. Okay, so that our conclusion then is this: claiming plenary powers, claiming that there are these matters that involve exercising plenary powers, that does not result in immunizing the administrative action from judicial review. So we'll turn then to the other kind of language, the other kind of argument that we see coming from the government in order to say that their action, the administrative action, is immune from judicial review. And that is this suggestion that government can have, that the administration can have, quote unquote, absolute and unfettered powers. And this language comes from the Hans Mueller case, and some of you might be familiar with that case. And people often look at that case and take out this part of the case that talks about matters of expulsion of non-citizens being absolute and unfettered, right? So that language of absolute and unfettered is given a lot of importance, and a lot is made of it. So we see why that language in Hans Mueller is might be subject to that interpretation, why it might give that impression. That's very strong language of absolute and unfettered powers. But what we want to say actually is that judicial suggestions, these kinds of judicial suggestions of having unfettered, absolute, unlimited power, they have to be understood very carefully in the context in which they appear within that particular case. And they have to be understood as a part of the wider body of case law relating to citizenship and immigration, right? So if we look at that, if we don't just look at these three words, absolute and unfettered, if we look at how they appear and how they appear in the context of the case, and if we look at the other case law, the picture that we get is very different. The picture that we get is not that the government can make any sort of decision in these matters and courts cannot interfere, right? So let me talk about that in a little bit more detail. So if we think about the Hans Mueller case, it's true that they use this language of absolute and unfettered and unlimited power. But even as they used this language, they still tested the classification in the case of Hans Mueller against Article 14. And so really they were, on one hand, they may have been using this language, but what did they actually do in the case? They didn't say, oh, right, we're not going to do anything here because your power is absolute and unfettered. So therefore, what is our business here, right? We have to stand back. They didn't do that. Instead, they actually did judicial review, like they did classic judicial review. They looked at the decision and they tested it against Article 14. So it does not seem in any way reasonable when you take the case as a whole, when you read the case and you read that language in its context, to take that language of absolute and unfettered literally. Now, it might, that language of absolute and unfettered, we think is significant. It does have that it does have some significance, I think, for deference, for instance, and Balu will pick up on that point later. But I don't think it should be taken as meaning that courts cannot interfere and that administrators have absolute discretion over that particular area of administrative action. So, you know, and if we look then beyond the Hans Mueller case and we look at the wider case law, again, courts have actually been really clear that such a thing does not exist. That is absolute and unfettered powers in that sense of courts cannot interfere, you have no recourse against the administration, that does not exist. So BP Singhal case says, but where the rule of law prevails, there is nothing like unfettered discretion or unaccountable action. The need of the degree of need for reason may vary, and this will come, I think, to Balu's point later about deference. The degree of scrutiny during judicial review may vary, but the need for reason exists. That is to say, the court might show some degree of deference, but that is not to say that there cannot be judicial review and that the scope of administrative law of judicial review does not extend to these kinds of matters. Now, another, I think, important case, Satwansik, and this is about someone who's denied a passport. In that case, one of the aspects of the rule of law is that every executive action if it is to operate to the prejudice of any person, must be supported by some legislative authority. Secondly, such a law would be void if it discriminates or enables an authority to discriminate between persons without just classification. What a legislature could not do, the executive could not obviously do, right? So here's a matter again dealing with passports, immigration, one of these areas that the government is asserting absolute and unfettered powers. And here's the court saying, look, if you're going to claim the rule of law, there cannot be this idea that there is absolute and unfettered powers in the sense that the court cannot interfere. Okay, so I'll hand over now to Balu, because like I said, while we want to say very clearly that the argument that there are aspects, there are areas of administrative action that are completely immune to judicial review. There are areas where judicial review, where administrative law cannot venture, that we think is not well founded. But we do believe that that language of absolute unfettered, the language of plenary powers, points to some areas where courts may and do in fact exercise more deference. So Balu, I'll let you take over on that point.
Thank you, Farah. I'm constantly having some issue with my device and I keep getting logged out. If that happens again, I'll try and log in from another device. So just excuse me as I make the transition. So as Farah has very clearly demonstrated, so there is absolutely no circumstances in which the courts in India are willing to, the constitutional courts are willing to say you have absolute and unfettered powers and there will be no judicial review applicable to these actions, right? But you also see instances where the court, for all purposes, act as if there is no judicial review. And this can only be explained by the fact that there are instances when the court believes that it should accord a lot of weight to the views of the executive. And they act in a highly deferential manner, so deferential that you almost start questioning whether there is, in fact, judicial review when it comes to these specific issues. But at the same time, it's a mixed bag of case laws, especially in the context of citizenship matters, where 1 minute the court is willing to step in, examine the validity of administrative actions, and in the next minute, even when presented with facts which clearly point to, in fact, even a threat to the life and personal liberty of people who are before the court takes a completely hands-off approach and say that, look, we are going to defer to the wisdom of the executive. Now, at a more general level, we'll come to citizenship matters in a bit. At a more general level, Jalan and Rai have proposed this hypothesis that looking at a lot of the Supreme Court judgments relating to
Oh, I think we've lost Balu, so hopefully he'll be back. But maybe I'll just speak to what he was going to say so that we don't lose time. So I think Balu was I think making the really important point that when you look at the broad. Oh, Balu, you're back. Okay, I was about to try to make your point, but you go for it. You do it much better than me.
Sir, you're on mute. Balu, sir, you're on mute.
Sorry, can you hear me clearly now?
Yes, sir.
Okay, thanks. So sorry. I think and the camera is a little tilted, but I'll just go with that for now. So at a general level, Jalan and Rai have made this point that when it comes to general administrative actions, and they don't define what general means necessarily, they give examples to illustrate what they mean by general, and they say that look, when it comes to say economic and social policy making, which is a general administrative decision making, or say when rules and regulations, subordinate legislation is being framed, the courts generally tend to be extremely deferential. But when it comes to specific decision making, and they give the example of say granting a license, or say in even matters involving personal liberty, then the court scrutinizes administrative action more strictly. So they are less deferential, right?
Now, if you sort of put this hypothesis against citizenship matters, you can't quite, it doesn't really, pass the test because the court is again very haphazard when it comes to citizenship matters. So there are a number of cases, and Farah referred to Hans Muller already, where the court was willing to apply the touchstone of Article 14, but the way in which it worded the application of this test, it referred to reasons of state, and it kind of used the language which suggested that it was going to be deferential towards the wisdom of the administration here, right? And similarly, very recent cases, in 2020, there were two High Court judgments from the High Court of Kerala, where two foreigners were stranded in Kerala during the pandemic. And, they sort of almost on a humanitarian basis, they said, look, please direct the administration to extend our visas because we are going through this extraordinary situation. But the court, again, the language it used is that, look, these are matters concerning national security. We have judicial review is minimal, so we are not going to step in here and direct anything to the executive. Now, it's interesting here again that the court say that we are sympathetic to your concern, right? But there is nothing much we can really do here because this involves national security. So once the mention of national security happens, it's almost as if court doesn't really look behind the veil of national security and see actually whether the cited ground of national security actually holds up or not. And perhaps the most significant example, especially in the recent times, of how courts are extremely deferential when it comes to citizenship matters, is the Muhammad Salimullah versus Union of India case, which all of you know was about the deportation of Rohingyas. And in fact, there were oral observations from the court itself where it acknowledged that we understand if these refugees are sent back to their country of origin, they might be persecuted for their identity, right? Even then, the court took a completely hands-off approach, saying that this involves matters of national security. The union has made a serious allegation relating to the implications for the internal security of the country, right? Of course, when judiciary tries to step into these matters, it's ultimately when it involves issues of national security. It's true that it will have to defer to the executive, but you see a trend in these cases where the court are highly deferential. It doesn't even make the effort to see whether the claim of national security holds up on the basis of ground realities. But this is a set of the highly deferential cases. There are instances we can point to which indicate that the courts can be less deferential, right? So one of the classic examples for this is the NHRC versus State of Arunachal Pradesh case involving Chakma refugees who for many decades have been living in Arunachal Pradesh as refugees, and their citizenship applications were kind of not forwarded by the district magistrate or collector for the purpose of processing their citizenship applications. And there the court very actively intervened, and this is again it's a specific administrative decision, right, whether or not to forward that application here. But the court decided to actively intervene and said that, look, these people have been here for so many decades. You have to make a decision on their citizenship applications, and directed the district magistrate to forward it to the union government. This perhaps fits into the second category of it being a specific decision. But still, if you look at it from another perspective, it is a larger decision, general decision making as to whether this entire group of refugees should be given citizenship or not. So here again, it's not clear whether it because it's a specific decision that the court has decided to intervene or not. A number of other examples can be cited in this regard, where the refugees they are detained in detention centers, but the court intervenes, and in some of these instances they are about to be deported. Court steps in and says, look, do not deport them for the time being, give them a shot at their citizenship application, until the point that the citizenship application is actively considered, we are not going to allow them to be deported, and they give a specific direction to the state in this regard, right? So anyway, the point here is that clearly there is a sliding scale as to the court being highly deferential in certain instances and not being very deferential in certain other instances. But on what basis exactly does this scale move is something which we can't easily discern from the case laws that we have in front of us. And the court themselves haven't made an effort to explain on what basis the scale moves. And I think some of the recent instances when it comes to national security issues are interesting in this regard, where the Media One channel case, where a news channel in Kerala was taken off the air recently, and they were not provided any reason by the government as to why their channel is being taken down, and they approached the Kerala High Court, and the Kerala High Court sort of merely relied on a previous Supreme Court judgment of Digi Cable Networks, where the court said, look, if there is a matter of national security involved, even principles of natural justice might not necessarily apply, and the administration can be almost like given a free hand to do whatever it wants to do, right? So this again makes things even more confusing. So we have been talking about how the courts are willing to step in, how they are willing to be less deferential, how the executive doesn't have plenary powers, but in many circumstances we see that the court almost acts as if they don't have powers of judicial review. Now, it is not clear as to what exactly can be a standard to be applied here, and what is the kind of test that the courts can come up with in order to make sure that they intervene on the right occasion and do not intervene, say, in a matter involving completely something which should be left to the executive's wisdom. I think we have, in some ways, good yardsticks, and number of speakers I'm sure have already spoken about it. But then again, it goes back to the points that Farah has been making, that look, when it comes to both constitutional grounds of review and common law grounds of review, our jurisprudence is in somewhat of a mess. So the courts themselves are confused as to what are those occasions when they should be more deferential, and what are those occasions when they are less deferential. So with that, I'll hand it back to Farah to make a few more points on this.
Thanks so much. Thanks so much, Paul. That's great. So I want to talk just briefly, because I know that we are almost out of time now. But I just want to talk a little bit just to wrap up. Really, I think it's quite important that we think critically about the state's claims, about the government's claims, when it comes to these areas that are supposedly, a matter of plenary powers, or where they have absolute discretion, or even these areas where supposedly the government, or the courts have to be very, very deferential, right? Because it's almost as we've heard from Balu, this language or this idea that, oh, we have no choice, this is what we have to do. It's a matter of national security, or it's a very sensitive matter relating to immigration or refugees or whatever. We don't want to get involved in this very sensitive matter. But there's actually lots of ways to get around any, for instance, national security concern. If we take this I'm taking a very, very extreme case, because then if you take a less extreme case, there should be no problem at all. So if you take a very extreme case where the government has been doing something, or the administrator has been doing something which involves very, very highly classified, very sensitive decisions or matters that cannot be revealed in open court, right? Maybe we can even go further and say it cannot be revealed to any lawyers even, right? So there are other jurisdictions that have dealt with exactly this kind of problem. And, just to give you one example of how they have dealt with it, they then appoint what is called a special advocate. And so even though, and it may even be that the matter is so sensitive that even the person who is affected cannot be told about this about the the national security issue or the basis on which the administration or executive made their decision. But this special advocate will then be told all the facts, and this will be someone who has high level security clearance. This is someone who the government is happy to give that level of security clearance with, a high level judge who also has that security clearance. And the special advocate will represent this person who's affected, and that person may not be told everything. Maybe it's not safe to tell them or whatever, but they at least have an advocate in a closed proceedings who is in a position to challenge the government action, right? And maybe that's not going to be a published decision, maybe it's not going to be open court, but there is a way to do it which both honors the fact that this is a rule of law society where the executive and the administrators are subject to the rule of law, and at the same time protects the government's legitimate interest in national security. So I just want to end by saying these are the sort of creative things that I think we need to look into, and not just accept some suggestion of that there is no way for the court to intervene when these matters come up. Okay, I think we'll end there. And just on behalf of Balu and myself, thank you so much for having us and for our time here.
And thank you, Professor Farah and Professor Balu. It has been a pleasure to have you both. Thank you so much for your insightful and informative session. Farah is contributing immensely for the growth of administrative law. Basu is one. Mr. Balu also one of my best student. Thank you both of you. Yes, over to Farah.
Okay, a pleasure. Thank you.
Thank you, Farah ma'am and Balu sir, for such enriching session, for highlighting the scope of administrative actions in India, discussing the grounds and the limits of judicial review and the position of plenary powers and absolutely unfettered powers in India, and the extent of deterrence in review. Thank you so much for joining us today. For the next session, I will ask Tanish to take over.
Thank you, Shweta. So, good morning, everyone. On behalf of the NUJS International Conclave on Administrative Law and our student fraternity, I would like to extend a very warm welcome to our guest, Honorable Mr. Justice Anirudh Bose, and to all those who have joined in to participate in this discussion. While I am sure that Justice Bose needs no introduction in the legal fraternity in India or abroad, I will still try to speak a little about him in an attempt to give our viewers insight about how he has contributed towards the development of jurisprudence in India. So, after a tenure of roughly 19 years as an advocate in the Calcutta High Court, where he practiced on constitutional, civil, and intellectual property matters, Justice Bose was elevated to the High Court as a permanent judge in 2004. He continued to serve the Calcutta High Court until early 2018, after which he was appointed as the Chief Justice of the Jharkhand High Court in 2018. On May 24, 2019, Justice Bose was appointed as a judge of the Honorable Supreme Court of India. As a judge of the Supreme Court of India, Justice Bose has delivered path-breaking judgments on fundamental rights and duties under the Constitution, reservations, international arbitration, and even criminal law. He has also been a part of more than 5 constitution benches, which have or are currently tasked with shaping the way in which fundamental freedoms and laws are understood and applied across India. Today, I am honored to introduce Justice Bose to you and to moderate this session where His Lordship shall be speaking on contemporary issues in administrative law. The audience is requested to remain on mute during the session. And if our viewers have any questions for Justice Bose, I would request them to post the same in the chat box, and I shall take them up accordingly after the address of Justice Bose. Now, I would just like to request our Vice Chancellor to welcome Justice Bose, after which he can take over the floor. Thank you, sir.
Welcome, Justice Bose. Good morning, sir. He's in mute. It is another 1 minute, perhaps. Good morning, sir.
Good morning.
Good morning. Welcome to our NUJS 2 days International Administrative Law Conclave. and we are eagerly waiting to hear your long experience and the trends of administrative law in India. So, hearty welcome to the session. Now it is your time to address the students and faculties also. So, we are glad to hear you. Thank you, sir. Please deliver your lecture.
Well, nice Sunday morning to fellow panelists. I mean, all of them may not be on the screen or in the podium right now or in the auditorium right now. Echoing, I think somebody has to mute.
Not
Yes.
yet. Everyone should make their microphone mute.
So I think my fault that I come address yesterday because till echoing everyone's mind. Uh, so everyone has muted the mic.
Yes, sir. We've muted everyone here.
Uh, let uh, say look at it again. Way could it be something mind setup?
Sir, perhaps you could try joining once again if that's possible.
Okay, then I'm turning on the camera. I'll come back in
Uh,
2 minutes.
I think sir has joined. Sir, can you hear us?
Let, let try on.
Sir,
Yes.
I think there is another link also open from your end.
Uh, maybe
So I think you can try joining from another device if it's possible.
yes,
Yes, sir. You're audible now.
yes. Well, I thank Mr. Chakraborty and organizer to give this opportunity. I think I think we are 1 day old, this program or seminar. So all of you have discussed what? 1 minute. Again, this is no problem. Maybe
Actually, two links at a time open. There are two links we are seeing. Another place also in your name there is a link open.
Another link, okay. That's muted.
Sir, I believe it is the Hotmail ID through which the other link is on. So if you could try and quit the meeting from that.
Okay, 1 minute. Give me 2 minutes. Yeah, Hotmail ID. New. Okay, at least on the screen.
Yes, now there is no.
Now, yes.
Yes, no echo now.
Okay, thank you for pointing out the technical error and for kind of remedying it. Now, in course of 1 day, I guess you've analyzed threadbare what constitutes administrative law. But I need a link to start with. So I'll just briefly kind of express what I feel are the basic ingredients of administrative law. This is executive action in respect of which one can approach the law court for remedy. It's well, the first pillar is natural justice. Okay, right of audience before steps are taken one against one. Then also the principle of justice to be seen to be done. No one should be a judge of his own cause. So in service jurisprudence, if you include that in administrative law, no one should be, the complainant should not be the inquiry officer or disciplinary authority. Next one you've heard often enough, Wednesbury unreasonableness. I'm sure that that principle also you must have had discussed. I'm guessing. Has it been discussed in course of yesterday's meeting?
Briefly, yes, sir. Briefly, yes.
Now, I think in the other common law jurisprudence, Wednesbury principle is the end of the scope of interference. That is the purity of the decision-making process. Now, if you open Wikipedia and read the piece on administrative law, in the Indian context, two other subjects have been added. I'm going there because that is the natural destination of everyone who wants to understand the subject in a brief. They are doctrine of proportionality, and the principle of legitimate expectation. Proportionality, we all accept. We meaning, I'm not speaking as a judge, but as a student of law, like all of you in the bigger canvas. And the next one is legitimate expectation, which on its own leg is yet to become a principle on which relief is to be given. On the other hand, one step behind of that is doctrine of promissory estoppel. So there we have converted a principle of law of evidence into a weapon to protect or enforce fundamental right, holding an authority to its promise given to a citizen. Now, I shall briefly go back to the reason as to why administrative law as a branch of law has evolved to such an extent. The traces of administrative law were always there in constitutional jurisprudence. There are English tomes, tomes in English. Professor Wade has written about it. Professor Desmith. Now, when did it really evolve as a separate branch of jurisprudence? My personal feeling is after the Second World War, when the reconstruction process was going on throughout the throughout the globe, the executives' entry into many fields increased exponentially. You read an Indian appeals, the Judicial Committee of the Privy Council decisions. On rare occasions, you will find the principles of administrative law. A decision on him. But from 1950s onwards, possibly in the Indian Supreme Court, Commissioner of Police against Gordon Das Bhanji, that might be the first case of administrative law, at least one of first. So I wouldn't go to the case laws much, because essentially what I'll do is I just express what is kind of in my mind as an administrative law. See, with the increase of state interference as a part of post-war reconstruction and as a part of developing the decolonized nations in Asia and Africa, the executives entered into many fields hitherto was considered no entry zone for them. What was the government function before this period? policing, for which there is entire criminal law and police acts, etc., etc. Then foreign affairs, over which still courts do not interfere broadly. Defense, there was little interference, but now this army tribunal has come up, which is dealing with complaints of members of the defense forces. And in terms of commercial activities, there were some regulations. In the field of tax, mostly there were tribunals, or in Indian context, there was Board of Revenue. What we understand as writ jurisdiction today had not evolved. The interrelationship between two parties or multiple parties in respect of other areas of living, which often gives rise to litigation, were regulated through legislations, and normally civil courts were the forum where people went. Now, communication, postal service, in India it's been controlled by government, but in many other countries it was private, but both in India and England. I'll refer to England sometimes because our jurisprudence, as we understood it for a very long time, was essentially based on principles of English courts pre-Constitution, before Constitution came into existence. Then we incorporated certain doctrines which were prevalent in the US, though that was also a common law country, particularly in the field of judicial review of legislative action. And now scholars are going deep into Sanskrit slokas, shastras, which is also revealing many principles we unknowingly attributed to common law, but was incorporated in our Dharma Shastra and other Sanskrit texts. So far, there was not much investigation into these areas because these were broad principles. Like in Mahabharata, if you read Shanti Parva, where Pitamaha Bhishma is kind of narrating how a nation should be run, many modern day concepts will come up from there. You try reading that. I think I'm right, it's Shanti Parva. Now in post-50s, railways, air communication, and even heavy industries, the government entered. Now the question arose as to whether the state, when it dons the apparels of a commercial entity, will they have free leeway like any other commercial entity in dealings with other commercial entities in course of business? A private businessman, when he procures say raw material, he can do it from anyone he feels like. Now, if NUJS is going for a big procurement, there's an elaborate process of tender, L1, L2, eligibility criteria we'll have to lay down. And the entire process has to be transparent. So, over the years, it's become as a principle established that when the government or its agencies, I'll come to that a little later, deals with any individual, then it has to follow certain norms. It cannot be that just because I like that person, I'll buy from him. And because of deep entry or deep existence of the state in many affairs of the day-to-day life, there were aggrieved people or people who have felt aggrieved by some even commercial decision of the state. They approached the court, and in many cases, they were entertained by the judicial system. Now, here the question which springs up in our mind is why? And in fact, in private, many persons say that this is actually hampering the normal functioning of an institution because of so much norms enforceable, because a private individual can take a decision, commercial decision straight away, and he may benefit from it by taking a quick decision. Two distinctions. A private person is playing with his own money. Of course, many times it's a borrowed funds, but the funds, though may be borrowed from a state agency or public sector banks or other institutions, they are accountable to the lender in a different capacity. But here, a lot of public funds are involved. And there is an obligation, being a state agency, that they should treat everyone in a fair and just manner, even if it's in the field in the commercial field or in employer-employee relationship. In the specific relief act, there was a bar on enforcing personal contracts. An employee dismissed if he felt it was an illegal process, he could not seek reinforcement, the termination order to be set aside. But over the period, industrial law evolved and so did the writ jurisdiction. And now, indirectly, it's possible to enforce personal contracts. And that is also a branch of administrative law in the field of employment. And in fact, the state tribunals dealing with this kind of grievances are called administrative tribunals only. That's one reason why the government was under this additional duty or obligation. The second one is the principle which has evolved as a doctrine of public trust. Whenever dealing with certain community assets, the state does not actually function like a private individual. They are a repository of the trust of the community or citizens whose funds they utilize for public welfare. And for that reason also, government can be brought to court. In fact, in my tenure as a judge, I have dealt with many cases of High Court employees who have sued the High Court administration, and in many cases the Chief Justice is the party in relation to service disputes. So that's the extent to which we are reviewing our own actions as an agency of a state. Now, who are the people who have this additional obligation? Is it only government? Over a period of time, the institutions or corporate entities in which the state has deep and pervasive control, that is the expression used in one of the judgments, are also under the duty to act just and fair in dealing with their activities which may impact some person in some way. So within this terminology of deep and pervasive control, many societies, cooperative societies, government companies, 617 in the 56 Act I'm not sure the new act, which is that equivalent section of government companies. They are also under this obligation to act just and fair. In the field of purely commercial dealing, what would be the principle that should guide an agency? There are two parallel views on this point. One line of authorities hold that when the government or a government agency altogether changes its characteristic as such and get transformed into another entity, then it can behave like such an entity as they're supposed to do under a specific law. You kindly read this LIC versus Escorts judgment, which will explain this concept. But again, in the field of tender, there are authorities that know whichever cloth you don or whichever robe you don, you remain a public body nonetheless, and you just cannot behave like a private individual going by your own whims or wishes without following these norms. Normally, cases are being decided on the basis of facts on this court. The other change which we are witnessing now is slowly rolling back of this government presence from many commercial fields. Now, normally a regulatory body is formed who will settle the price mechanism, which was earlier being done by the executive through its tariff fixing bodies. And these regulatory authorities, they have quasi-judicial character in dealing with these complaints or in say fixing the tariff. The tariff fixing for a long time has been held to be a purely executive action, even pre-rollback period. Only that purity of the decision-making process was subjected to scrutiny by the courts if somebody brought an action. Now, when state is again withdrawing from many fields it entered in a capital short era where funds were to be raised by the state agencies and transmitted for industrialization of the country, what would be the role of administrative jurisprudence? I think that is the primary question which we will face in the next 10-15 years. Suppose one government company, their employees had the protection of Article 14 and 16. It is disinvested. It goes to a private hand. So that protection the employees lose. In the field of public utility service, there are instances the citizens' right to approach the court are still being retained. For instance, the electricity companies, many of them are private players, but at least in the city you are in now, not the Salt Lake side, across the road, the electricity provider is a private sector company, and there are a series of writ petitions in High Court over bill dispute, meter dispute, this, that. So far as they are in the public utility domain, the courts have generally entertained the petition provided it has merit. But what about the obligation of that company to maintain these special norms in their purely commercial dealing with other private players or with their employees? The general view has been that no, that would not come within the branch of law known as administrative law, and court in its writ jurisdiction would not interfere in such actions. There are a couple of authorities taking a different view, but those are few in special circumstances of the situation. So there's one case, Sri Lanka Vidyarthi. It was, you kindly read that. It has not been overruled, but not referred to very often. In this judgment, a two-judge bench of the Supreme Court observed that whenever the state acts, it acts as a state. It won't be Dr. Jekyll and Mr. Hyde and categorize their role in their dealings in these two capacities, in public utility area and general legal area. Next is who can approach the court in these changed circumstances. One principle which is followed is the person concerned must have an enforceable legal right. Now, what is enforceable legal right is again a tricky area, and it began with a judgment called Calcutta Gas, 1962 Supreme Court, which held that there must be a legal right to enforce, to access the constitutional jurisdiction of the High Courts and Supreme Court. But at the same time, it didn't clearly lay down what would constitute legal right of a person. Now, there is one line of judgment: a commercial rival does not have legal right to object to even illegal activities of a competitor. One case in which there was a regulation that a particular rice mill and in another a cinema hall would not come within a particular zone. Some distance has to be mentioned. Now, a license holder, he complained about breach of that particular norm. And there are decisions that no, a commercial rival does not have the legal right to object to his competitor's action in violating the law. This has been followed in cases of Motor Vehicles Act in the field of licensing. The new Motor Vehicles Act, 88-1, it has liberalized the licensing policy, and the old license holders, primarily for commercial reason, wanted to block entry of new operators on the pretext of some legal violation. Or so the courts all over the country have held that no, you don't have right to object to your competitor's entry into the field. There are some, again, this field of law is yet to be finalized properly, or possibly it cannot be finalized because each case has to be decided on its own fact. Final view may have to be taken whether a competitor can object to a rival trader's activities which would impact on commercial benefits of the competitor or the rival trader, whichever you look at it. So these are the, now of course, this kind of litigations are transformed into public interest litigation and brought to court. And there also court is now, or law courts all over the country are now kind of scrutinizing the real intention behind what has come to be known as public interest litigation. These are the broad areas in my mind which will dominate the administrative jurisprudence of in our country for the next 15, 20 years. And I must add here, because of the constitutional provisions which has cast duty on the state to act fairly and in a reasonable manner, which is Article 14, we have seen development of administrative jurisprudence. Jurisprudence, or rather, Indian authorities are now cited in various other common law jurisprudence more often than before. You'll see news that an African court has kind of followed our court's decision on right to privacy. Public interest litigation is being kind of attempted in various other jurisprudence. At least in the field of constitutional law, if you look at Malaya Law Journal or Dhaka Law Report, I think DLR, that is the reference, or any Pakistani law reports, there are elaborate references to constitutional decisions by our courts. Now, there is, of course, the ultimate question. I mean, okay, if we introspect, the question which really we have to face is, to what extent there shall be judicial review. The critics of the extent to which we practice judicial review, the critics say that there is some decision making, there is too much encroachment into the decision making process. Executives would say, we have not fallen here from the sky. We have also entered through a legitimate process. We must be given certain latitude. Now, this criticism is coming not only from legal academics, but some from various fields, including some of our retired eminent judges, that we shouldn't judge every step that's taken by the executive to reach a destination. But here, my own answer, and I elicit your views also, is that courts do not interfere for their own, or to enhance their own glory or show their own power. The court is reacting to a situation at the complaint of a citizen. So court reflects citizen's voice. And even in the legislative field, when a lacuna is found over a long period of time, then cases like Bishakha has to come. So it's part of judiciary is not outside the state. Judiciary is part of the state, an organ of the state. So it is on all the three organs operate on mutual respect. But one difference with many of the civil law countries and the common law country like England, which recognizes parliamentary sovereignty, is that we, the legal community, I won't say judges alone, the legal community has been vested with the duty or conferred the duty by the Constitution to protect fundamental rights or legal rights as enshrined in Constitution from state action. Thus, the scope of judicial review is inbuilt in our Constitution. And law courts will have to act in the event it is found that there is breach of fundamental right. See, why was Keshavananda Bharati decided? Till 1967, the view of the court was all parts of the Constitution can be amended. Then the country went through a little bit of, not little bit, in 67, momentary political changes. And it was then Goloknath case came. Now here I must admit I am under certain limitation because of the post I am holding. All of you have right to remain silent, but we have a duty to remain silent in certain areas. So I won't dwell on that till I demit my office, retire. We can have a more elaborate discussion on that. But the point I'm trying to emphasize is court doesn't create a situation in which it creates a new law. The need for a particular type of legal interpretation is felt. And normally after some time, when for whatever reason, there's a lag in making a law in that field, for the purpose of protection of fundamental right or constitutional right of citizens, court has to come and lay down certain norms. Again, I'll give the example of Vishakha. And in spite of being a part of various international treaties, there was no implementation mechanism for the problem dealt in that case. So essentially, it's one of the finest example of judicial lawmaking. So even in England, Lord Radcliffe, who had the author of the Radcliffe Award, he had said it's right to say that judges make the law. In England, in spite of parliamentary sovereignty, judges are making law since 14th, 15th century. This entire common law is judge-made law. and they are responding to a particular situation. If you look at Donoghue against Stevenson, see, because that snail case, see, because of industrialization, there was a mass marketing, packaging. Donoghue Stevenson came in response to that. So courts are usually the first, I wouldn't call it a sounding board, but the first forum available to a citizen to enforce a right which is evolving. Now, so either courts alert the other organs of the state that this is the problem, or if that complaint can be linked to some violation of any of the fundamental rights, then court responds. And no one has made any complaint about the Vishaka case. Many of the environmental litigation, we have one of the best environmental jurisprudence in the world. And these are essentially, if we look at administrative jurisprudence in a bigger canvas, these are essentially part of that. Ultimately, they are dealing with executive action, whether it's a filling of water body or clearing forests, blocking rivers. These are all executive actions with which we are dealing with. S.R. Bommai case possibly is the highest level of administrative law, because they are the ultimate executive of the state. His action was subjected to judicial review. Now, I have ended my, okay, in a room like this, it feels like a soliloquy. And if it's technically possible, I'll like to interact with you. Professor Chakraborty, is that possible? Or I've gone beyond time?
No, it is possible. At least 10 minutes, we can have some question discussions.
Right, sir. And I already have got some questions for you while your talk was going on.
But I've told you my duty to remain silent. So
Definitely, sir. So if you feel that a question may not be answered, I think you can exercise your absolute discretion in that. So my first question is from Ayushi, and she asks that how does the judiciary approach the matters of administrative secrecy, especially now when transparency and accountability are regarded as the mainstays in modern governance?
see, in the Evidence Act of 1872 itself, there was provision for privacy protection, privileged communication, husband and wife, and the state also could take privilege, the section 123. So it's not a very modern development. Now, technology is creating some problem for us, for the state, for the citizens, and I'll leave at that. Privacy is protected, and that kind of protective parameters are there in the law of evidence itself. It was one of the best, it is one of the best piece of legislation in the world. I think Professor Chakraborty will
No,
agree.
right, it is right.
And the same who had drafted that, I'm just going beyond the topic now. Stephens, he was given the duty to create a law of evidence in statute in England, but he became ill and couldn't finish that. And many of the Indian codes, etc., the actual author is Stephens, though it's attributed to Lord Macaulay. And the personal laws, it was Warren Hastings' initiative. Yes, but where we have failed is we have not been able to dig out the modern principles which may be available in our Sanskrit texts. I read one article by Professor Hiren Mukherjee. He was a CPI MP, I think, and also a barrister himself. He had written in that article, I have not kept that the Pandits from Bhatpara, which is a place not far from where you were situated, they have shown me many Sanskrit slokas which are fitting into the concepts of Marxism also. So we have a treasure which needs to be mined. And maybe there is one Tagore lecture on interpretation of law by in the Indian context.
Mimamsa rule.
Mimamsa rule. So along with Maxwell, you kindly keep it next to it and try and match. Yes.
Thank you, sir. I think, yes, that really answers Ayushi's question very comprehensively. There's another question by Agniva in the chat box where he asks that, sir, so you had mentioned in your lecture that the Supreme Court is now deciding cases on facts. So in reference to that, he asks that in the realm of administrative law, do you think that the Supreme Court should be doing the task of fact-finding?
No, I haven't said Supreme Court decides the cases on facts only. Supreme Court decides the cases on law arising from a particular set of facts. So we are not a fact-finding court, except in Article 131, where suits can be filed in the original side of the jurisdiction, suits between union and state or two states. And there's another set of rule for this water disputes. And
All
now
right.
what are we, I mean, what are we having to decide? Airwave. We didn't know it existed when I was studying law. So there's something like that which could be commoditized, monetized, and marketed. Now that CAB case changed that. Maybe somebody will claim some royalty on sunlight at some point of time. Like with magnifying glass, we transform, we kind of concentrate sunlight and can generate, ignite fire. So whoever had invented that, he could have had claimed a patent on that. But these are all outlandish claims which are coming up, and I think from purely objective view, Indian judiciary has taken a very balanced approach.
As living tree, our Supreme Court is a living tree. It will grow.
Yes. And it doesn't answer a question in a vacuum. See, Vishaka case came when many women were in the workplaces. When there was no lady staff, the question of Vishaka did not arise. And now batsman has become a batter. maintain the gender equality. So everyone is respond to a time, and that's how it should be.
Thank you, sir. I think, yes, that answers Anura's question as well. So if there are no other questions, I will now proceed with the vote of thanks. Yes, Dr. Chengappa, we want to say
Yes. I would like to thank the Honorable Justice Aniruddha Bose for spending precious time and sharing very important issues with respect to administrative law. Sir, the audience really have taken note of it, and we will look into it, and it will help immensely for our the teaching as well as research the activities. Thank you very much, sir.
Thank you, sir, for having broadening
Your
our
lecture
perspectives
food for
today.
thinking, all the teachers and students, how it is growing, what are the futures. Thank you, sir.
I'm only leaving food for thinking because I can't have that cup of coffee.
Yes, sir.
Post session.
Next time, we are hoping that in the campus itself, some Saturday or Sunday, we'll get you to interact lively in our.
Sir, we used to attend almost all our programs, sir, at NUJS.
Allowed. Do you have any society on public law?
Not public law, we have administrative law societies. There,
Constitutional law society we have.
constitutional law. We have a constitutional law society.
So if we make it that includes public law.
Yes.
And it would be a good idea to follow certain other jurisdictions where
Yes.
this constitutional law is evolving. South Africa is one. And,
Comparative jurisdiction.
yes, because in many jurisdictions there's a rollback
Yeah.
of judicial interference. Again, maybe need of the time.
At that, this Dr. Chengappa teaching to LLM, we have compulsory paper on LLM, comparative law, comparative jurisdiction, comparative law is a compulsory paper, all the postgraduate law students. So that would be a very much needed. We can have a workshop on that. Only comparative jurisdictions in the present world.
And I'll also request all of you, there's this Hamlin Lectures
Yes.
publication. You should, I think the students should read all of them.
Lecture series, perhaps we have now. I am not sure, but when I was in Mohsin College, I purchased that. This time in the market, I have not looking that. I will search whether it is continuing.
In website, they have downloaded, I mean, they have made available
Acha.
all the lectures.
So I will ask my library if print copy not available to download and keep it.
I don't know. I'm not commenting on that because I'm not sure of copyright law. So, but anyone can read it. There's no bar in that.
No, sir. In the copyright law, it is said that any university 3 copies can made from the website for research and elimination of the knowledge.
OUP case is there, Delhi High Court. You can make.
Thank you, sir.
Thank you.
Yes, sir. Thank you so much, sir, for having broadening our perspectives today and having enabled us to go beyond the realm of teachings in classrooms. And your session has been a glowing testimony to the fact that there's a chasm of sunlight between what we are taught in our classrooms in law school and what the profession expects us to be like. So thank you for having encouraged us to bridge that gap today. And now I would like to just thank all the participants for your attendance and engagement in this lecture. And I would like to thank especially Vice Chancellor Dr. Chakrabarti and Dr. Chengappa for their enthusiasm and their untiring commitment to make this event a success. Thank you so much once again and have a great day. I would now like to call upon Astha for moderating the next session. Thank you. It's been an honor, sir. It's been an honor, sir.
So I'll sign off now.
Okay, sir. Thank you.
Good morning, everyone, or as it is now, good afternoon. On behalf of the NUJS International Conclave on Administrative Law and our student fraternity, I would like to extend a very warm welcome to our guest, Mr. A. Shanmuga Sundaram, and to all those who have joined in to participate in this discussion. Sir has over 32 years of combined litigation and in-house experience. He has practiced in the Madras High Court and civil courts. Presently, he is working as General Counsel at ITC Limited. He has also contributed several articles and blogs on various topics covering constitutional law, tax law, labor law, and administrative law. He will be speaking today on dynamics of principles of natural justice as a ground of judicial review from an administrative law perspective. Today, I am honored to introduce Mr. Shanmugaram to you and moderate this session where he shall be speaking on contemporary issues in administrative law. If our viewers have any questions for the speaker, I would request them to post the same in the chat box and I shall take them up accordingly. Now, without further ado, I would like to invite Sir to begin his address.
Thanks, Asta. Thanks for this kind words. I would like to make a small PPT presentation for the viewers to follow. Friends and scholars, it's my privilege to address this august gathering on a topic of great significance. I thank the West Bengal National University of Juridical Sciences, its Vice Chancellor and faculty for giving me this opportunity. Sorry, the PPT is not coming.
So, is it visible now?
Yeah, yes.
Okay, sir. So, please let me know when to change slides.
You are doing it.
Yes.
Thanks. As most of us know, you can go to the next slide. As most of us know, the principles of natural justice have their origin in common law, which shaped and molded these principles. The much quoted statement of Bracton, the king should be under no man, but under God and the law, demonstrates the importance of legal principles even in a monarchical form of government. Asta, can you move to the next slide? Judicial administration is a quest for finding the truth in order to remedy the infringements of rights of one by another. In regular courts, we have two parties, each presenting their respective cases to an impartial judge who, after hearing both these cases, decide the disputes between the parties. But we do not profess that in the process, the courts would necessarily find the truth. The standard of proof in a court of law is that after considering the matters before it, the court either believes it to exist or considers its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon its supposition that it doesn't exist. This is the definition provided for the word proved in the Indian Evidence Act 1872. So, when a party who loses the case might believe that his or her case was not justly decided by the court. To err is human and the judges are human. Therefore, we prescribe reviews, appeals, and revisions in the judicial administrative system to remedy any error that may crept up in a judgment. Still, the truth may elude the courts. We have many instances where it was later found that the courts had erred or misunderstood or wrongly applied the principles. Still, when the principles of natural justice are followed, they instill confidence among the public. As Lloyds put it, the rules of natural justice are those which made it probable that whatever the matter to be decided, the decision will be right. So a process which is regularly and diligently followed would result in a just decision is the belief. One might wonder, how complex could these principles of natural justice be if they are so sacrosanct for the administration of justice? Like all fundamental principles, these principles of natural justice are also simple. The expectation, as Lord Norburn puts it, is that the courts must act in good faith and fairly listen to both sides. For that, it is a duty lying upon everyone who decides anything. With the development of society and administrators performing the role of regulators as well, their actions affected the individual's rights. In the previous speech, Justice Bose explained what are all the circumstances in which the role of an administrator transcended into a quasi-judicial function. The courts have distinguished these actions from the regular administrative functions and termed them as quasi-judicial functions. In determining the quasi-judicial nature of the act, the Supreme Court has prescribed 3 standards in Province of Bombay versus Kusal Das Advani. A, the body must have legal authority. B, the authority should be given to determine questions affecting the rights of the subjects. And C, they should have a duty to act judicially. Unlike the courts, where a disinterested judge decides the dispute between the parties, between 2 different parties. In a quasi-judicial function, there are only 2 parties. The authority deciding a dispute cannot be described as completely disinterested in the dispute. The authority may or may not be trained in law. The procedural rules and rules of evidence do not apply to quasi-judicial functions. Still, it is expected that if the authorities follow the principles of natural justice, a fair decision shall be reached. UK courts have generally held that any violation of principles of natural justice would render a quasi-judicial order void. Prior to Ridge versus Baldwin, the courts have treated these principles as procedural infractions. But in the classic case of Ridge versus Baldwin, the House of Lords held that not furnishing the charges to the appellant and not providing an opportunity to him resulted in violation of natural justice, and the proceedings were held to be void. While the principles of natural justice are as ancient as the natural legal system itself, the application of the principles of natural justice to quasi-judicial functions is relatively new. Lord Reed's remark in Ridge versus Baldwin that we do not have a developed system of administrative law, perhaps because until fairly recently we did not need it, shows that the administrative law is a later development. Subsequent to Ridge versus Baldwin, the House of Lords in several judgments shaped the functions of a quasi-judicial authority and the scope of judicial review. These principles are compiled and listed by Keith in his article, Ridge versus Baldwin 20 years on. Those principles are A, opening up the processes of government prior to decision, requiring that the discretion be properly and fairly exercised by the ministers, requiring tribunals to exercise their powers in accordance with law and providing the citizen with access to information after the event and enable the citizen to effectively challenge the decisions of the administrative authority. These positions have been followed ever since. Coming to these principles of natural justice, there are mainly two principles. A, no man a judge in his own cause, and B, hear the other party. If you look at these principles from a different perspective, they would be the expectation of every individual who would be discharging the quasi-judicial function if the roles are reversed. Yet, many scholars have noticed that the Supreme Court's judgments on the principles of natural justice resulted in inconsistent jurisprudence on similar questions. I refer to Raisa Vakil, Constitutionalizing Administrative Law in Supreme Court, an article published in 2018. You can also see New Prakash Transport Company versus New Suvarna Transport Company, where the Supreme Court held that the requirement of natural justice may be waived. And if you see F.N. Roy versus Collector of Customs, AR 1957, Supreme Court 648, Supreme Court held that there was no obligation to provide personal hearing at every stage, and holding that the refusal to give personal hearing at an appellate stage did not vitiate the principles of natural justice. But we are not alone. In UK, ACAS observes that the distinction between direct and collateral attack based on whether a judgment is void or voidable resulted in a distortion and letting the court to ignore the principles of natural justice, and the definition of jurisdiction has varied widely from case to case. Before we delve into the main topic, it's relevant to remember that in administration of justice, one important aspect is to give finality to the dispute. To this end, our procedural law contains several provisions. Res judicata is provided under Section 7 of the Code of Civil Procedure. Failure to include all claims in a litigation will deny the litigant an opportunity to initiate a subsequent proceedings under Order 2, Rule 2 of the Code of Civil Procedure. Withdrawal of a suit without leave of court will give an end to the cause of action and all the claims under Order 23, Rule 1. And the provisions of the Limitation Act are intended to bring in a finality to all claims if the claims are not initiated within time. In all these issues, the courts have consistently held that the rights of the respective parties are not extinguished, but the courts will not enforce them and will not assist the parties who are not vigilant in enforcing the rights. Let us move on to our first principle: no man a judge in his own cause. The courts have identified several biases. This is a principle of bias, and the courts have identified several biases that affect quasi-judicial function. But for our present discussion, let us focus only on the official bias or departmental bias. One of the leading cases on the subject is Gullapalli Nageswara Rao versus APSRTC, which we all call it as Gullapalli 1. In this case, the Secretary to the State of Andhra Pradesh was to hear the objection from the interested parties about the proposal of the state government to nationalize bus transport in certain parts of the state. The court found the fact that the Secretary to the Transport Department conducted the inquiry offended the principle that the authority empowered to decide the dispute between opposing parties must be the one without bias toward other side and cause the order passed. And we all know that the matter did not reach any finality there. Subsequently, in Gullapalli Nageswara Rao versus State of AP, which we all known as Mullapalli 2. The Supreme Court upheld the order passed by the Chief Minister in the same matter. The court gave 3 reasons for its decision. A. In Mullapalli 1, the petitioner argued that the objection should be heard by the Chief Minister and not the Secretary to the Transport Department, and having argued, now he cannot challenge the order passed by the Chief Minister. B. The position of the Secretary of the Department and the Chief Minister of the state are different, and the Chief Minister was not part of the department. C. The petitioner had not filed any affidavit averring that the Chief Minister made certain statements prior to the hearing which disclosed the Chief Minister has predetermined the issue, and the Chief Minister has denied making any such statements in his impugned order. The first 2 grounds, we could discuss it at length, but not here. Many scholars are focused on the second ground, which we all know about, this official bias, making a distinction between an officer of the government and the elected representative holding a post. But in the present discussion, let us focus on the third. Several newspapers reported a statement by the Chief Minister that the government was determined to implement the scheme. These newspaper reports were filed before the Chief Minister during the quasi-judicial proceedings. The court observed that if it was established that the Chief Minister had made these statements, there would be considerable argument in the petitioner's case, and that the Chief Minister heard these cases with preconceived notion. Only on that ground, it rejected it. The court rejected the argument, holding that Chief Minister, in his order which was impugned before the court, denied making such statements, and the petitioner did not examine any person who heard the Chief Minister making these statements or filed any affidavit in this regard. This goes against the principles established in several cases where the Supreme Court has held that the quasi-judicial authorities are not bound by strict rules of evidence or procedure, with the exception being the principles of natural justice. I refer to this Union of India versus T.R. Verma, AR 1957, Supreme Court 882 in this regard. One wonders if the court was facing the dilemma of taking its conclusion to a logical end and declaring the proceedings and order void. Was the standard expected by the court was to prove beyond any reasonable suspicion that the Chief Minister has a preconceived notion? In reality, the standard of proof required in the administrative judicial review is not actual bias, but the reasonable suspicion of bias. If that standard was applied, Gullapalli Net 2 should have resulted in a relief to the petitioner. And let us move to the next principle, here the other party. This simple and natural right to be heard has taken several forms over the course of time. The quasi-judicial authority is required to provide a notice stating the proposal, reasons or grounds on which the proposal is being made, provide all the materials and documents relied upon by the authority to make the proposal, provide an opportunity of hearing, and opportunity to lead evidence and cross-examination, provide a reasoned order for its decision. These are all the several forms. In Cooper versus Wandsworth Board of Works, the court granted damage to the plaintiff when the local board demolished his building on the ground that he started the construction without first making an application. The court held that the plaintiff's failure to make an application could be explained, but the board's failure to comply with the principles of natural justice and provide a prior notice was not excusable. And we all know at home we have this Maneka Gandhi versus Union of India, a celebrated judgment. It was stated that based on a view expressed by Justice Frankfurter B.N. Rao, the advisor to the Constituent Assembly, did not recommend incorporation of due process clause in our constitution. Maneka Gandhi changed this position. It held that the procedural fairness is part of Article 21 and paved way for expanding the scope of Article 21. Let us see the relief granted to the petitioner in Maneka Gandhi. The petitioner complained that her passport was impounded without providing any notice to her. The court found that by impounding the passport without providing notice, the authority acted in contravention of the Adi Altram Patam rule and the provisions of the Passports Act 1967. The logical conclusion of this findings would have resulted in the order being set aside. Yet, the court accepted the statement by the government that it would give an opportunity to the petitioner and hear the petitioner before confirming this order, and on that basis this case was closed. We could read many judgments on these principles, but now having read these few cases, let us move on to the reliefs provided by the courts when these actions are challenged on the principles of natural justice. The approach of the courts in India could be understood from an observation made by the court in M.V. Bijlani versus Union of India, 2006, 5 SCC 88. The court said, after having held that the impugned order violated the principles of natural justice, the consequence of the said order would have been to remit the matter back to the disciplinary authority. We, however, do not intend to do so, as the charges relate to the year 1969-70. The appellant, due to pendency of these proceedings, has suffered a lot. He is therefore directed to be reinstated in service if he has not reached the age of superannuation. However, keeping in view the fact that he has not worked for a long time, we direct that he may be only paid 50% of the back wages. He is also entitled to cost of this appeal counsel fee assessed at rupees 5,000. This judgment was passed in the year 2006. We could notice a similar trend in many judgments. Only in few cases the courts have allowed the proceedings to come to an end. For example, in Mahadayal Premchandra versus CTO, AR 1958 SC 667, Sinha Govindji versus Deputy Chief Controller, AR 1966 SC 269, State of Bombay versus Nurul Latif Khan. In all these cases, the courts have allowed the proceedings to come to an end, declared the order void, and let it go. But in many cases, the courts have allowed the authority to start a fresh inquiry. If you see State of UP versus Warm Organic Chemicals Limited, 2010, 6 SCC 222, Vipul Boy, Mansingh Boy Chaudhary versus State of Gujarat, 2017, 13 SCC 51, BSM PG College versus Samrat Sharma, 2019, 10 SCC 56. In all these cases, the court remanded the matter back to the authority, asked them to provide an opportunity to the petitioner before decide the matter afterwards. For a change, in some cases the courts have gone beyond these limitations and also granted relief to the petitioner. In State of Bihar versus Reserve Sugar Company, the court set aside the order passed by the authority suspending and not renewing the license given to the respondent and directed the government to refund the license fee paid by the petitioner for the suspended period as well as the period for which the license was not renewed. However, the court did not consider or grant any compensation or damage for suspending or not renewing the license without following the principles of natural justice. These judgments explain the court's dilemma in giving finality to disputes. We all heard Justice Bose explaining the scope of judicial review. Judicial review is a review of the decision-making process, whether the authority below followed the principles of natural justice or not is the only scope of judicial review of administrative or quasi-judicial action. The judicial review of quasi-judicial or administrative function is not intended to replace an appeal. The court would only see if the natural justice was followed or not. If it was not followed, it would be sufficient. However, by allowing the authorities to start the proceedings afresh, the courts have demonstrated the reluctance in allowing the disputes to come to a formal end only on the ground of violation of the principles of natural justice. This is not the dilemma faced only by the courts in India. If you remember the famous statement of Cardoso that the criminal is to go free because the constable has blundered, and Justice Clark's replied that the criminal goes free if he must, but it is the law that sets him free. That provides a glimpse of the conflict faced by the judges for ages. In conclusion, if we see what aids the application of principles of natural justice is the lack of finality given to the proceedings. The courts understand the principles clearly and state them, but the courts in India at least are reluctant to end a list in quasi-judicial matters only on the ground of violation of the principles of natural justice, as the disputes on merit would remain undetermined. In Mapp versus Ohio, a similar conflict was faced by the court, where the evidence before the court was excluded by applying the exclusionary rule. That is when the Cardoso's observation and Justice Clark's reply, which I have cited before, arose. The court said, if the evidence was obtained by illegal means, the court will not recognize it. If that results in a criminal being set free, that would be the consequence. And dealt with that firmly. What would be the consequence if the court continues to remand the matters? The litigant before the court who complains of violation of the principles of natural justice would suffer one more litigation for no fault of his. The litigant will be discouraged from challenging the proceedings on natural justice, as success in that case would not give him any remedy, because he would again be remitted back to the authority for one more hearing. On the other hand, the quasi-judicial authority or administrative authority that has nothing to lose, and they could start the proceedings afresh. This will increase complacency or lethargy in adhering to the principles of natural justice. If these cherished principles of natural justice are not working, and there is no remedy, where do we go? And in the same jurisprudence, let us look for that. Austin, when he was explaining the law, he was explaining about the law and the consequence of that law. He explained if there is no sanction attached to the law, it is an imperfect law or a law of imperfect obligation. So in India, when the matters are remanded back without any further consequence, the natural justice are being reduced to imperfect laws or laws of imperfect obligation, as they lack sanction. The court should make it clear that violation of the principles of natural justice would render the quasi-judicial proceedings void. Such proceedings would not be allowed to be reopened unless there is a fresh cause of action or change in the circumstances. any attempt to circumvent the principles of natural justice should be dealt with firmly, and the authorities who demonstrate repeat behavior in this regard should be divested of their quasi-judicial powers. If these actions are taken, we can see a hope that the principles of natural justice would reclaim a respect in our judicial administrative system. I hope I have given this gathering some pointers on a well-known yet well-diluted principle. Any views, questions, contrary opinions are welcome.
May I, sir?
Please.
Yeah. Sir, so first of all, thank you very much for your deliberation upon the principles of natural justice. Sir, it is not my question. Actually, I want to know your opinion. If we look into the journey of the judicial opinion from the mere likelihood of bias to real danger of bias, if we look into this transition, don't you think that this narrow interpretation made by the judiciary ultimately violated the concept of natural justice itself?
Very good question. I was reading about a foreign author making a comment on Indian scholars that we are all Blackstonians. So we look at the judgments and discern the principles. We do not look into the basis of the judgment and make a comment whether it is right or not right. You are right. See, in bias, administrative bias or bias in a quasi-judicial function, it's a complicated subject because there is a bias, an inherent bias in an administrative quasi-judicial authority. Therefore, when the court look at it, the reasonable scope for bias was the standard. That was the original standard, consistently applied by the courts all over the world. But for some reason, strange reason, when it came to India, the judges have analyzed the cases very clearly, understood the principles, explained them, but when it came to the relief part, they were reluctant to give relief and give finality to the matter. Therefore, they started making this fine distinction by stating that reasonable scope of bias to a real likelihood of bias. A similar distinction made by the Supreme Court in the tax case in this the distinction between tax planning and tax evasion has been now discarded by the Supreme Court, saying that no, it is a fine distinction, and Supreme Court did not express it. You are right. Likelihood of bias should be the basis, not a real likelihood.
Yes, sir. Just I want to add, and if you agree on that, actually, maybe the judiciary decided the matter for its own convenience, that to avoid the multiplicity of suit. Okay, this is one of the reasons for narrowing down the test. For example, under Section 64 of the Sales of Goods Act, caveat emptor, the rule, it is very smaller in comparison to the exception. Similarly, you are saying, nemo judex in causa sua, personal bias, the very large one, but you are narrowing it down. Then ultimately from the litigant's perspective, and just look at the Indian scenario, that is the half of the people, they are very much, I should say, powerless, or they are not aware about their own power or the right. Now, how can we, how the judiciary, instead of catering justice, they are taking away the concept of justice from these people? Don't you think that the judiciary is somehow responsible for that?
See, yes, you are right. And I will again say it is again because the court was reluctant to end the matter only on the principles of natural justice, because like Justice Bose was explaining, it was not deciding the case on facts. It was deciding it only on principles. And that is why I cited this Mapp versus Ohio, a hard fact. The court concluded that the petitioner was a criminal and his crime was proved. but the evidence was obtained by illegal means, and therefore court applied the exclusionary rule, which is a rule of procedure, and said therefore that person will go free, and we are administering law, and in that duty we are setting him free. Not if the constable has blundered, you take an action against him, train him, improve him. So when the court makes a fine distinction like a real likelihood to a real danger, it is only the court which can understand it. Not even a lawyer can understand. The lawyer can only make a plea and make some set of facts to decide whether there's a reasonable apprehension or a real likelihood apprehension. Therefore, it leaves the entire principle to a vagueness.
Thank you, sir. Thank you very much.
Any other questions? The observations? Thank you very much, sir. You have come all the way to NUJS to take part in this, the conclave, and sharing your knowledge. Over to Asta.
Thank you so much, sir, for giving us this practical perspective on something that we only learn theoretically. And this has enriched our knowledge about this topic, especially regarding how dynamic this topic is beyond the classroom. Thank you so much. And this has reiterated the importance of the principles of natural justice coming from the perspective of administrative law when it comes to judicial review. I'd like to thank sir for being here with us today. I'd like to thank everybody for attending this session. I'd also like to thank Chengappa sir and VC sir for giving us the opportunity to have this conference at NUJS. Thank you so much. Now I'd like to hand over to Shreya, who will be moderating the next session. Over to you, Shreya.
Thanks.
Thank you, Asta, for handing me over the floor. We'll just start in 1 minute.
Shreya, you're not adequately audible.
Okay, yeah, thank you, Asta, for handing me over the floor. We'll just start in 1 minute. Yeah. So, Sairam sir has already joined. So, hello everyone. Welcome to the 5th session on the second day of International Conclave on Temporary Issues in Administrative Law. The guest speaker for the session is Professor Dr. Sairam Bhatt. Sir is a professor of law at National Law School of India University, Bangalore, and Center Coordinator for Environmental Law Education, Research and Advocacy, an eminent center at NLSI itself. Sir is also a visiting researcher at Georgetown University Law Center and has completed his LLB from JSS Law College, Mysore, and LLM PhD from University of Mysore. Sir has served as an editor of Card Law Journal in 2005 and 2006 and Law Relating to Business Contracts in India at SACE Journal in 2009. Sir has also authored several scholarly articles and papers in reputed journals and publications. He has received Young India Environmental Law Fellowship in 2003 and has also been awarded with Linnaeus Pan Academic Exchange Fellowship at Royal Institute of Technology, Stockholm, 2012 and 13. Today, Sir will be speaking on the topic RTI as a tool for good governance. As we all know, right to information is intrinsic to good governance as it upholds all the pillars of the same and is an effective tool for attaining the goals of good governance. The true goal of a representative government is the welfare of people, wherein RTI stands for the notion of accountability and transparency in the system, along with affirming the inclusivity and participation of the common people. So now, without further ado, I would hand over the floor to Professor Bhatt to start the session. But just to quickly remind you of the structure of the session, the participants shall be on mute at all times while the speaker will be speaking. But they can put their questions in the chat box or they can raise their hand when they want to ask the questions. Now over to you, sir.
Yeah, thank you.
Namaskar, sir. Namaskar, sir.
Dr. Sanjeet, very good afternoon to all of you. Dr. Chengappa, respected Vice Chancellor, participants of this very interesting workshop on administrative law. Let me put across certain thoughts for discussion. I I don't intend to make a presentation. I don't intend to lecture, but I just intend to raise certain issues for our consideration. And I would request the audience to react to it. You don't have to necessarily ask me questions if you don't have any, but you can contemplate on some of the issues that I'm bringing forth for this workshop. First and foremost, friends, I have based my discussion on the right to information for a couple of reasons. First and foremost, I think it's been 17 years of the Right to Information Act being enacted in India. This October, it will be 17 years. 2005 is when this law was made. And the intention of this law was to ensure or bring about some degree of transparency and accountability in administration in India. Because we were looking at citizens demanding information, citizens demanding accountability of the government. I think the Right to Information Act was very well intended. It came about. It changed, according to me, the attitudinal issues that were required in government. There was fear for some time. I don't know if many of you have interacted with officers who were public information officers during that time, but there was fear. They feared that citizens can demand information. They feared the fact that citizens can hold them accountable. They feared the fact that they had to pay a personal penalty or a fine. So I think to some extent because of fear, डर grades के लिए अच्छा नहीं, ये आमिर खान ने बोला था, but डर administration के लिए अच्छा है. ये मेरा perspective है. But I feel that that change that RTI brought was very, very effective in one sense. But I want all of you to think that are we happy with whatever RTI has done so far? And is it sufficient to do with RTI alone? The presentation, friends, that I want to make is what is the next stage of transparency in this country? What should India aspire for? Should we look at any new law, legislation, scheme, policy, or regulation to take the transparency and accountability movement to the next level? I think this is something that I want all of you to think about, and maybe you can add some ideas to the ideas that I have to present before you. So I'm looking for a new legal change because I'm not happy with whatever we have. I think we have to improve it. Why should we improve? Why should we bring in more transparency? Why should we bring or discuss about more accountability of the administration? Many of us would say, sir, I think we have transparency and accountability. Right? Many of us would say that. But as per ratings, I don't think any of us like ratings, NUJ is this rank, NLSI is this rank, we don't like it. But ratings can give us some degree of what I must say, channelization to improve ourselves, to one sense. Right? Everyone wants to be number one. But if you look at Transparency International, they do not rate India very high in terms of transparency and corruption. Right? We are still somewhere at 86th position when it comes to transparency, accountability, and handling corruption. We may be the 5th largest economy in the world. We must be the second in terms of, say, after China, in terms of population, the second biggest country. We are going to Mars and space. We have everything that's going good with us, but probably we are not doing very well when it comes to transparency, accountability, and the fight against corruption. So the ratings have not changed in the past 17 years. So do we have work to do? Should we think something good to do? I think so. Those ratings can give you some indicators regarding that. Interestingly, friends, I've always looked at corruption under the lens of the fact that, yes, we created Lokayukta, right? We created Lokpal. These were supposed to be ombudsman. Now, when it comes to Lokpal, Lokayukta, Central Vigilance Commission, the CAG, they're great institutions. Probably they're doing their job pretty well. And I think they have exposed a lot of cases, case studies for corruption for all of us to discuss. But maybe somewhere, are they losing some kind of a steam, and are they not able to reduce the levels of corruption that is expected by, say, the international society? It is a time probably to introspect some of these institutions, because I believe that it's not only legal reform that is important, ladies and gentlemen. I think it is administrative reforms that is equally relevant. Because you can create institutions, no doubt, like the Lokpal or the Lokayukta, but you have to have the institutions taking the responsibility in the constitutional principle or in the spirit of the constitution to actually tackle corruption. So maybe the institutional reform is the next agenda. For example, in Karnataka, Professor Changapu would definitely relate to this. I can just give you an example of my state, that the Lokayukta had the power of the police. But unfortunately, the police power was taken away from the Lokayukta, and the Lokayukta feels helpless in actually going about its autonomy in terms of its independence in tackling corruption, because there has been change, which the political system obviously brings in for its own purposes. So is there enough debate of what needs to be done to make institutions like them more relevant so that transparency, accountability, and corruption can be handled? Going forward, ladies and gentlemen, let me also highlight this fact that we always focus on corruption in government. Yes, because we are on the other side, we are either in the academia or in the judiciary or in the bar, and we find the government is corrupt. Yes, government corruption is a huge problem. But how many of us actually think corruption in the corporate life is also a huge problem in India? Do we think so? I'm not sure if you have thought so. Now, corporate level corruption, because please note, corruption is a matter of public life behavior. That public life may be as a government servant, that public life may be as a director in a company. Now, just a couple of days back, if some of you have been following corruption in the National Stock Exchange, NSE, very high profile managing director has been found to have entered into so-called unethical corrupt practices in managing a stock exchange. Corporate stock exchanges where mine and your money are invested, if imagine corruption happens in such sectors, please note, we are not talking of the state versus citizens, it may be non-state versus citizens as well. Now here is where my emphasis is on. Please note, today we are looking at ease of business ranking. Unfortunately, that has now been stopped due to the controversy of how this ranking were given. But India attempted to, fight for a better ranking in the ease of doing business, because we thought the country must attract investment, we must attract, foreign companies to this country, and how can we do that? We can do that if we improve our ranking over here. Interestingly, when you look at the ease of business ranking, is corruption a major issue? It can be, it should be, because businesses also fight corruption within and externally as well. Now, external corruption with government giving, there is a lot of administrative issues in giving licenses, permits, and sanctions. We all know about it. But what about internal corruption? We know agencies like SEBI, the Reserve Bank of India, the regulators that are there in the specific sectors like IRDA, DGCA are trying to do their job in bringing about better governance, what we call as corporate governance. And we brought corporate governance thanks to some of the changes that we did in the Companies Act of 2013 as well, getting independent directors, so on and so forth. I believe reforms have done, but have they done sufficiently well? Because we have seen a lot of corruption with these corporates. Because there is corporate greed, money, profiteering. You have to impress with statistics to your shareholders, saying the company is doing very well. And then there is, please note, secrecy. The most important area that we need to tackle in administration, both in state and as well as non-state actors in India, in our economy, is to remove this level of secrecy. Wherever secrecy is there, it breeds corruption in one sense. And that's why we say transparency is the rule, secrecy should be the exception. If you look at NSC, you will clearly classically come to this opinion that maybe the breeding ground for all these unethical, illegal practices was the way NSC was managed very secretly. Now, interestingly, friends, please note it down. NSC was declared as a public authority under the Right to Information Act in 2010. None of us probably want to relate this episode of NSC with the RTI Act that we are discussing today. NSC resisted. They said we are a private organization. We are not a public authority. So we will not. thought that was a question, or maybe that was an intervention saying time is up. Okay, whichever, no problem. So the fact is, I'll just take a couple of minutes, friends. I'll open it up for some discussion if you have any, but I'll just put across some of my thoughts before you. So NSC was declared as a public authority. The point is, friends, when I say what should be the next stage of transparency movement in this country, friends, tracking corruption in corporate life, please note, tracking corruption in corporate life, I have come to this conclusion that the Right to Information Act needs an amendment. And what should that amendment be? That amendment should be that every institution in this country, whether it is public or private, must be open under the Right to Information Act, must be accountable under the Right to Information Act. So we must ensure that public limited companies should be accountable under the RT Act, which unfortunately is not the case right now. Because corporate life has to be accountable to the public, because what do the corporates do? Maybe they're tapping the natural resource of this country. Maybe they're trying to use the sovereign territory of this nation. And hence that system of accountability should be not only towards the regulator per se, it should be to the public, because the regulator may not demand accountability. So let the public release demand it. It should not only be demanded by shareholders, it can be demanded by someone else as well. So I think the definition of public authority under Section 2H of the Right to Information Act should be amended is my proposition before you, so that corporates can also be brought under the Right to Information Act. We can evaluate it, good, bad, and ugly of the same, but that's my firm proposition looking at the trends of corporate corruption in this country. Let's move a little bit forward. The next proposition, friends, I have for you is, let's stick to the ease of doing business. The government is trying to do a lot of efforts in the ease of doing business. We wanted to improve ranking, and hence, please note, friends, one of the reforms that we took was to bring the commercial courts. I don't know how many of you have heard of what we call as the commercial courts. We have heard of family court, we must have heard about motor vehicle courts and so on and so forth, but I'm not sure if law students have actually focused really on commercial courts. Commercial courts are specialized courts, friends, right now, which can actually look at contractual dispute. They're specialized courts. They're not established everywhere, but yes, some states have already done it, and most of the contractual disputes can be referred to the commercial courts. The reason was that under the ease of doing business, we were ranked very, very low in contractual enforcement. Judgments come, the A party wins over B party, but finally this judgment cannot be enforced in India. See, judgments look good on paper, but finally in practice and reality, parties and litigants suffer because they're unenforceable in this country. Why are they unenforceable in this country? Who is responsible to enforce judgments and decrees in this country? Police? The deputy commissioner of the state? Who should take responsibility to ensure effective enforcement in a time-bound manner? Because finally, friends, I may win a case, but within a time-bound manner, if the judgment is not enforced, naturally my rights are going to be disturbed. So in contractual enforcement, and please note, contractual enforcement is of business. Contractual enforcement is of corporate trying to make commercial gains. And if there is a delay, those commercial gains can be lost. And the country had to improve its ranking on contractual enforcement. And that's why we brought the commercial courts. Great. Now, interestingly, if you look at the Commercial Courts Act, the rules, and so many things that has been done over there, it is something very laudable. For the first time in India, please note, when I said institutional reforms, why institutional reforms are so relevant? Let me tell you, we brought in what is known as the case management guidelines under the Commercial Court Act. Case management. So when should the preliminary hearing take place? Within how many days it should take place? How many adjournments can be granted? When is the... So every kind of guideline has been issued over there. Great. So we have done, but finally, how many parties are willing to go to the commercial courts? Why is arbitration still an alternate forum and matters are not referring to the commercial courts? So is the commercial court institution not getting enough matters? And why arbitrators and arbitration is actually flourishing in this country? Why aren't we focusing on actually saying, okay, the courts are here, please refer matters to the court and not for arbitration. So you will look at systematic problems that need to be tackled in some of these cases. And hence, I believe, friends, that institutional reforms in this country, especially which deal with dispute resolution, are critical. They're very important, and we must speak about it. Now, judiciary is a key institution in this place. Judiciary and even quasi-judicial, including tribunals, are key institutions. But my whole worry is, and that's why when I said what is the next stage of transparency that we aspire or should aspire for, probably my personal attention is towards the judiciary. Because the judiciary seems to probably be a little slow in implementing some reforms. And everyone looks up to the judiciary, and rightly so. But it's not just criticizing the judiciary is what my issue is. I don't want to criticize the judiciary. I think systems are changing, but I think some more can be done. Now, in terms of the right to information law, the judiciary has been a reluctant institution. And interestingly, if you look at the R.S. Mishra case, which is the Supreme Court judgment, the judiciary does not want to entertain RTA applications directly. Yes, the Supreme Court does not want to do it. While I understand there are administrative issues, but please note, those can definitely be ironed out. You still have to show, ladies and gentlemen, a good cause to seek information from the apex court. And you have to apply under the Supreme Court rules, not under the Right to Information Act. So why should the judiciary resist the kind of transparency that is there, which is equal to the legislature, to the executive, and to the judiciary? Interestingly, some of the high courts have developed rules under the RTA because they're competent authorities. And those rules also actually are inconsistent with the RTA, to be honest. Yeah, that's definitely there. So I think institutional reforms are relevant because you can't just focus on administration. You have to focus on the judiciary because they go in tandem, right? I need a judicial judgment, but I need its enforcement as well. So is the enforcement the role of the administration, and how that coordination actually can be done so that contractual enforcement can also be increased to some level, which makes India probably an attractive destination for investment, attractive destination for employment, and attractive destination for governance as well. Friends, at this point of time, I believe I should shift from the judiciary to the political parties. Friends, the political parties are also equally a reluctant institution when it comes to embracing transparency and accountability. Despite the fact that the Central Information Commission has held that the political parties should be covered under the Right to Information Act, so far most of the political parties have resisted the change. They don't want to be held accountable. They say we will decide how much to give, what not to give. So you will notice that unless the political system, the judicial system, and the administrative system look at law or embracing the law of transparency as something that is good for not only the citizens, for the country, but also for themselves. Because finally, friends, only when you are accountable, you will hesitate to commit any corrupt practice. If someone is watching you, let me tell you, that's what I always say through RTA. RTA is like the CCTV camera. If someone is watching you, the temptation to commit any illegality or unethical activity is less. And hence, I think institutions like the political parties in this country ought to accept the fact that this is good for everyone, including themselves as stakeholders. And it would also, to an extent, please note, friends, bring democratization of the decisions in the political parties, which I think is very important in a democracy like us. How do you elect? Who do you elect? Who becomes a chief minister? How do the president occurs? Is there voting secret ballot? I think there is a need for such kind of ethical norms that the political parties must adopt. And hence, I believe, friends, if the RTA law or if any new reform in this sector ought to take place, these changes are inevitable for the country to go forward. Friends, the point that RTA is good for this nation, some of us have already tested its success. But the fact is, there are many challenges. And the challenges are, we have a legislation called the Whistleblower Protection Act. I don't know if some of you have read about it, written about it. I think it's very, very critical and important. But the fact is, this law needs more impetus. There could be a whistleblower in a university who would want to probably say that there are certain illegalities, irregularities that are happening in universities, and they will want to demand some kind of a protection. Now, the fact first is the Whistleblower Protection Act lacks the kind of legal literacy that is required in this country. Not many people know, nor do they discuss, nor do they seek protection under this legislation. Because unless you disclose you're a whistleblower, unless you seek protection, you'll be exposed. And then if you're exposed, please note you'll be threatened, blackmailed, and finally you could be murdered as well. A lot of these so-called activists have unfortunately faced a lot of death threats. Now, whistleblower protection, friends, is a critical element in the transparency and accountability movement. We want people to come as insiders and expose organizations and institutions for their corrupt practices. This is the best way we can actually get information that there is some kind of unethical, irregular, illegal activities happening in institutions. So you need to tell, you need to suggest, you need to protect, you need to have mechanisms and guidelines. We have seen whistleblowers in other countries seeking asylum, running away, and so on and so. You know how the state can actually chase you, isn't it? We know that definitely. So I believe, friends, though the act is there, there is lack of awareness, there is lack of literacy, there is lack of application, there is lack of discussion, debate about this legislation, and please note, lack of extension of the whistleblower law to all organizations. Because I believe, friends, whether it is private or public, every organization has secrets. Like every family has, every individual has. And there are some secrets that others have the right of the business to know in public interest, and hence they should actually be looked into. Finally, friends, let me wind up with two other things. I won't expand these two aspects, but I'll just put it across to our young audience over here. Friends, interestingly, we have been talking about privacy. We have been talking about data protection. Interestingly, today, when we talk about information, we are in the digital information era. Every information is online, digital. How do you balance between privacy of an individual? How do you look at data protection? And how do you look at information under the Right to Information Act? How do you balance these? Friends, there are a lot of critical elements over here. A lot of critical elements. And all of these critical elements have to be addressed. Now, the Data Protection Bill attempts to do that in some extent, but not adequately enough in terms of how it will actually balance the privacy of individuals under the Right to Information Act. I'm sure most of you know that challenges of data localization, challenges such as right to be forgotten, challenges such as sharing of data through either contract or mining of data. All of these will be critical elements as we go forward. And the Right to Information Act ought to actually react to what is happening right now. We cannot say 2005 law was good because it was not. 2005 looked at record in the paper stage. It did not look so much as records in the digitalized form. So we need to actually look at this legislation and try and say, right remains, but it has to be balanced with other rights, because that is what the Puttaswamy judgment said. Right to privacy is also a fundamental right. Right? So balancing of interest, balancing of rights, and we don't expect everything to be decided by the judiciary. Let the parliament take a call, lay on the test of this balance, and probably it becomes a clear law for application as we go forward. Finally, friends, the final point that I would like to raise before you is the Right to Information Act brought in some level of individual accountability. Now, please note, transparency is kind of a process. Accountability is something that you have to put it across. Now, accountability, friends, in India, brought through the RTA Act, was actually a great legislation. When the movement was strong, now why do I say the movement was strong during those days? It's probably withered away of late. When the movement was strong, please note, the government enacted a legislation called Public Service Guarantee Act. Some states passed it. But interestingly, friends, if you evaluate the Public Service Guarantee Act, You will notice that the accountability from RTA was extended to the Public Service Guarantee Act, though the amount was reduced. From 25,000, it was reduced to 250. Now, if some of you know about this legislation, you will notice that you were guaranteed public services. Like what? Birth certificate, death certificate, which the state governments are involved, ration card. Once you apply, you will actually get this service in a time-bound manner. And if you don't get it, the officer will be personally held liable. Interestingly, friends, where should we take the Public Service Guarantee Act? Look at Delhi. The AAP government has said, we will take the public services to the doorstep of the citizen. This is a new initiative, and I believe it's the great initiative, which means initially the citizens would go to the office, they would file the application, then the documents, then wait, process, pay the fee, and then take a token number and come home, and then they will say within 3 days or 30 days the service will come. The AAP government has gone one step forward. They have said, just say what you want. The officer will come to your doorstep. He will do all the documentation, all the effort. He will give you a token number, and then you will get that service at the doorstep of the citizen. Citizen need not get out of his house. He need not run from building to pillar to offices to get some of these services. I believe if that idea can work, Delhi is a small state. I agree with you. Our government may be doing it as something of a political initiative before the Punjab elections. All those criticisms set aside, friends, I believe that's a great step in administrative transparency. It's a great service to citizens at their doorstep. And I think the state is accountable to those kinds of services that the citizen demands. I think keeping the political, social, and economic interest of the state. Why I say this? Some states may not have the administrative capacity to give citizens services at doorstep. We will have to understand that. Some states may not have the budget to do that. I understand all of that. But the fact is, those are steps that we should look forward for administrative change so that transparency and accountability in India can be strengthened from the existing processes that are there in this country. I hope I have communicated some ideas to you. Thank you so much.
Sir, if any of the participants have any questions, they can put their questions in the chat box. So yeah, okay, Ayushi, you can go ahead and ask the question.
Hello, sir. This is Ayushi. So, in furtherance of what you talked about, I would. Am I clearly audible? By the way, all right. So, in furtherance of what you discussed, I'd like to draw your attention to this very specific issue of national security whistleblowing. So, I have been reading this scholar, Rahul Sagar, who writes extensively on this matter. And he also proposes that, that the freedom of information laws that we have can only do so much to give access to information that are deliberately or perhaps excessively kept secret from the public. And then he also mentions, and he rather offers a very bleak perspective, that institutional measures really can't do the job because there could be biases and prejudices within the independent committees, let's say, if they're formed, that ultimately determine the conflicts. Now, my question is, or rather I seek your opinion as to, see, when we talk about national security, it's a sphere which involves a lot of sensitive information, and perhaps in a way state secrecy is justifiable because you really cannot do away with it. But at the same time, we would want that in a democratic setup, there is a sufficient flow of information so that the citizenry is able to make an informed decision. Now, this, for me, creates a conundrum because there's no way you can actually reveal a secret without actually revealing the sensitive aspect of it. At the same time, we are advocating transparency within this area because we have known a lot of corruption growing in the national security and intelligence sector. So I want to know your opinion whether either what Rahul Sagar says that institutional reforms perhaps may not work at all. Would you suggest whether they can or cannot, or whether there is no way out, or there is actually?
Thank you. I'm pretty optimistic in all things. You know, while we can always discuss challenges, but optimism is the way forward because solutions are always there for every problem. Only thing we need to think about those solutions. I think institutional reforms can definitely happen. There is no doubt about it. And to some extent, those are happening. But you are absolutely right in raising a very, very critical issue of national security, corruption, transparency, and accountability. You know, the bigger challenge I also see is privatization. So, you know, if you look at privatization of the defense sector, the challenges still continue to remain, right? And that's where I believe that we have to put our minds. We have to say, yes, while the state always has a right to withhold some information, remember that some should not be all information, right? I believe that there are parliamentary committees, joint parliamentary committees on defense, where this information at least must be disclosed. There could be sensitive information which at least the judges can scrutinize, like in some of the cases that the Supreme Court has already done. There should be audit reports without disclosing finer details, which can also be made public, like the CAG audit report in some of the defense procurements that are actually placed before the parliament. So I think some kind of check and balance is going to be the way forward, and I think those needs to definitely be strengthened. And I think the fact that you're looking at the civil establishment also trying to monitor defense procurement, this is kind of a joint responsibility. It's not pure defense or it's not pure civil. I think that would actually go a little bit forward in trying to bring about some level of it. But yes, finally, I think on the point that you rightly said, should you actually have some kind of a standard or a guideline or a definition of what amounts to national security? I think that's imperative. Now, I'm not saying we should always define for the sake of law to be defined, but I think citizens ought to know that this is where they can step in and this is where there is no way forward. I think that kind of clarity may be required at some point of time.
So may I add one question to the same thing? So, since you also mentioned about whistleblowing and Official Secrets Act, I think a recent amendment was proposed where they tried to curtail the ambit of the Inoperational Act of 2014. And I really want to know, I mean, if I were to address the question as to whenever a whistleblower is there in a national security setup and he perhaps fails to derive information from the existing RTI and he decides to blow the whistle, and the information he blows is irresponsibly done and it actually amounts to damage. So how do you address that? Because then it's on the public, on the other side, and the government actually didn't really be blamed for it.
So that's a very important one. So if you look at the Whistleblower Protection Act, the whistleblower has rights to seek protection, but he has duties also not to make things that are sensitive to the public. So I think the act is pretty well balanced. Yeah, and the rules also to a larger extent imposes that kind of responsibility as well. But you know, again, on the whistleblower in the defense sector, I mean, this is actually a very important issue. Now, a lot of I must say, victimization happens. And I think the government has a serious business to actually stop the same from, going further. There are officers who have lost jobs. The officers have been, inquired with. Disciplinary action has been taken sometimes. There is other forms of harassment that has taken place on such kind of employees. So I think that's an area that the government has a lot of work to do. I think the government must realize that it's a major problem. The government must, that's why, strengthen the Whistleblower Protection Act. And like, in the Vishaka guidelines, let me just say, because I was listening to the other speakers, now we know that this has to be publicized. We have to say who's the grievance redressal officer, where he has to go, what are your rights. Everything is now very well known. Why not about the whistleblower? Why don't we tell the defense forces, look, if you find some kind of thing, this is where you should go, these are your protections, feel safe, we will not see that you are victimized, you're not going to lose your job, some boss is not going to hold a departmental inquiry against you and terminate you, or so on and so. I think the intent of the government is not just pass legislations, right? Just making them good legislations paper will not matter. I think there must be an implementation structure, and I think it's up to us as citizens also to use this law and to spread the awareness of such legislation, so that I think these kinds of unethical behavior can come out. But great questions.
Thank you, sir.
So we have another question from someone, so you can go ahead.
Good afternoon, sir. Thank you for your address. Sir, you mentioned in your speech about need of transparency in the judiciary. So I just wanted a clarification whether you are arguing for transparency in all aspects of what they do, like there are decisions regarding the collegium that are sometimes put on their website, sometimes not, and there are also in-house procedure. So there appears to be a distinction between these actions. They would allow some decisions to be in public domain, some to be not. So do you create a distinction, or are you arguing like entire thing that they are doing on their administrative side should be put in the public domain?
Yeah, so the first distinction that the judiciary has made is they have distinguished between judicial function and administrative function. So judicial function, they say you can't ask. Administrative function, they have not said what it is. The point that I'm just driving to is the judiciary set the trend on right to know in the SP Gupta case. The judiciary set the trend in saying right to know is inherent in Article 19(1)(a) of the Constitution in the Association for Democratic Reforms versus Union of India case. It was the judiciary. Now, Sanjay knows this more than what I knew, because he is the one who contributed a fantastic article on that, on the constitutional perspective. So, Sanjay will give you more information, probably. But the point is, I think, okay, so don't take me otherwise, but I've always believed this from my limited experience in training on RTA. Preaching is easy. Practicing is very difficult. I can say, you should have high morals and high standards, but when it comes to me, I may find it difficult. So, I think when the judiciary was saying that the political parties must change, the executives must declare their returns, what did the judiciary do? The judiciary said, we will not disclose our returns. Yeah, no, it's not the current persons in the judiciary, but at one point of time, the head of the institution took that position. And I thought that was unnecessary. So we have people like Subhash Chandra Agarwal who have been fighting a cause. But let me tell you, there are so many judgments that the judiciary is not pronouncing at all. They've held it for many years. They've just not decided to even pick those cases, though they, I think, are very important, not only from a jurisprudential legal perspective, but also from a country perspective. The judiciary has not touched those cases. They have said, okay, we'll just let compliance happen, but we will not give the judgments over. So it's not criticizing the judiciary, but I think because every one of us looks up to this institution to protect the principles of constitution, to look at constitutionalism in this country. The judiciary is the final institution that we have trust and faith in. I'm just saying that the judiciary can actually strengthen this faith of every Indian citizen by taking some very proactive steps in bringing about transparency and accountability. That's what my appeal to the judiciary is. It's not a criticism. It's just saying that the institution can do much more, and that's it.
Thank you for your.
Sir, with your permission, since you took my name, I wrote this article in the year 2008, if I can remember properly, and I'm quite surprised that you have read it. It is always a pleasure to listen you. Samarth, so far my understanding is concerned about the entire discussion. I really want to quote and remember Professor Shamnath Bashir. One day in our faculty meeting, sir, Sharam sir, for your, just I'm sharing, the faculty meeting was going on in our university. And at that time I joined the university, I think, just 3 or 4 months, And I heard one line from Shamnath sir. He said that there should not be any statutory or institutional exception in right to information. Whatever you want, you can easily inform others. But if it requires to be a confidential one for some serious reason, now this seriousness is to be decided on the basis of the fairness. Now, your query about the judiciary, it is very tough to say anything about the judiciary always. But we are at a crossroad, actually. We have promised a lot. Now, it is a time either to follow that or to revert back. This is my understanding about the entire thing. Whatever sir said, I'm very much agree with it, sir. The issue of privatization, business, commerce, internal security, all this actually somehow compelled us, or put us in the crossroad. And now we have to decide, should we go further? Sir said I'm optimist. Yes, I want to be optimist. All of you should be optimist. But maybe, sometimes it is the sir, Sharon sir, just for your information, many of my students will also agree that how the legal institution, they are performing these statutory duties. Okay, they are paying 8,000 salaries, and they are compelling the faculty members to sign a document that they are paying UGC skilled salaries. This is the reality. So all these issues are to be taken, but I am very much agree, and thank you, Sharon sir, for lucidly explaining the entire thing and the issues. Obviously, the constitutional promises are there, the statutes are also there. I am not saying that all laws are bad. Yes, lacunas should be there. Yeah, we can't make a waterproof legislation. But how we are adhering those principles, this responsibility lies with us. Are we ready for that? This is the question. Thank you, sir. Thank you.
No, let me just conclude, if you don't mind. I'll just conclude by saying this. We all think that we have an opinion about cricket in India. Yeah, there are two things that all Indians have an opinion on: politics and cricket. Now, if you look at how the BCCI reforms came about with the intervention of the Supreme Court, the Supreme Court said everything is wrong with BCCI. Everything about the administration of BCCI. You know why? Because it was a secret organization. It was not open. It did not say we will be held accountable by any other law. And everyone tried to bring BCCI under RTI, they failed. Then it was the Supreme Court that had to step in to do some kind of change. Now, you will notice that the word conflict of interest that was laid down in the BCCI judgment is so very critical. If someone even thinks about it, why this important rule is there in administrative law and how it should be held applicable, I think we'll go a long way forward. Thank you. All the best.
Thank you for your insightful session. Extending Samath's question, he has rightly pointed out, if you look at Indian judiciary, the Indian judiciary was vocal until 2004. Indian judiciary in series of the cases asserted the right to know. Thereafter we come across, as you also rightly pointed out, so many cases are pending. We don't find constitutional bench hearing the matter pertaining to the public, the authorities. In my opinion, the judiciary should be more pragmatic, because RTI being the transformative legislation, it requires pragmatic interpretation. Then only we can bring political parties and the other institution within the purview of the RTI. Even IUC also rightly pointed out, we don't find balancing strategy between right to the privacy, right to security, and right to full disclosure. In my opinion, judiciary also not contributing the way in which it should have been contributed. Thank you.
Thank you, sir. Namaskar, sir.
Thank you very much, sir.
Thank you, sir, for gracing us with your presence today. It has definitely been an enlightening and thought-provoking address. I extend my sincere gratitude to you for taking out time from your busy schedule and gracing us with your presence. I believe each of the participants here have learned immensely from the discussion and interaction with you. Your assertions that transparency should be the rule and not the exceptions, and the insights into the way ahead with the transparency movement, and also the discussion and emphasis on the need for institutional reforms and transparency has definitely given us some important points to ponder over in the due course. So thank you once again, sir, for joining us today.
Thank you. Thank you all the way.
Thanks.
Are you saying announcement? Announcement.
So this is to inform all the participants that we will be going for a short break. We shall reconvene again at 2 o'clock. So with the sixth session of today. So hope you all join again. Thank you so much for joining this session.
Sir.
Go ahead. Sorry.
Good afternoon, sir.
Good afternoon, sir. I'm MP Changappa.
Yeah, good afternoon.
Good afternoon.
Good afternoon, sir. So shall we begin?
Yes, of course.
Okay.
We are right on time.
Yes, sir. Good afternoon, everyone. It is my great pleasure to welcome Professor Dr. Vijay Kumar to session 6 on day 2 of our international conclave on contemporary issues in administrative law. Professor Vijay Kumar is the Vice Chancellor of the National Law Institute, University, Bhopal. He has published extensively in national and international journals and contributed to a couple of books as well. His areas of interest and specialization include constitutional law, administrative law, human rights law of elections, and refugee and humanitarian law. With this wide range of knowledge and experience, he will be conducting today's session on public liability and individual liability in administration. It is not a very common topic to discuss, nor is it common to discuss issues of personal liability in the arena of public law. But in light of the growing number and prominence of misfeasance of public officials, it becomes crucial to discuss new strategies to compensate public and individual losses adequately. Before I hand it over to Sir, I would like to repeat the ground rules for today's session. I would like to remind everyone to kindly keep their microphones on mute at all times so that it doesn't cause any disturbance or interruption to the speaker. I also urge and encourage everyone to post their questions in the chat box as they will be taken up towards the end of the session. Today's session is an hour long, and with everyone's cooperation, we should be able to complete it in the stipulated time. I thank everyone for again joining in this session, and I now hand it over to Sir to conduct today's seminar. Over to you, sir.
Share my PPT if you would like to see.
Yes, sir, sure. So would you require our assistance in sharing your screen?
Just a minute. I'm just opening it.
Sure, sir.
Can you see my?
Not yet. Not yet.
Yes.
Yes, sir. Now we can see.
Now you can see?
Yes.
Okay, good. Right. Okay. Right. Yeah, good afternoon, everyone. It is a topic of great significance in administrative law, whether it is in India or overseas, because the process of administration gets reflected very clearly in the method and manner in which we enforce public liability along with individual liability in administration. If this is to be achieved, and that is why it is titled as public liability and individual liability in administration, issues and challenges, I would like to restrict my presentation with reference to India with occasional comparison with either UK or France for certain things. But otherwise, I will try to explain what this public liability is, whether there is any statute or whether there is any law, whether there is any constitutional provision to do that, and whether we have anything called as individual liability, either under the Indian Constitution and any exception is available. And then I'll try to see how and what are the challenges that we have to face in this process, right? Okay. Having said that, I hope you are able to see the screen now. This is about a Times of India news clipping on 12th October 2021. Not very old, 12th October 2021. Now, in that news clipping, what has been mentioned was that one among the accused, a superintendent, dies at the age of 80, employed in Union Carbide, Bhopal, in the gas tragedy of December 1984. Now, when you look at it, the tragedy took place in 1984, right? And in 2021, the one among the accused passes away. And then you can see that almost 38 years passed by, the accountability or the liability is not specifically fixed or even discussed in detail. So therefore, how do you react to this particular news clipping when you see 38 years later that one among the accused dies? And then what action has been taken? Has the compensation has been ordered or given? Can the government, either the central or the state, wriggle out of and become a prosecutor by itself to avoid its vicarious responsibility or public liability, which I would like to use, not very interchangeably, but that is how it is emerging, even direct, for not supervising these factories by the inspectors of factories and boilers.
So I'm so sorry to interrupt you, but your slide isn't changing. We're still on your first slide.
Yeah,
So
I'm
if,
still on the first slide.
okay, so if the news clipping you were trying to show us, we are not being able to view it.
Oh, okay.
So if you could.
Can you see this slide now?
Yes, so we can see the first slide with the name of your presentation and all of that.
Now change.
So no, we can't see the changed slide now. We're still on the slide number 1.
So you can click on slide number 2, sir.
Yes.
Yes, now we can.
Yes. Now we can view it, sir.
But you can't see the full screen.
So I think that should be. That's nice.
Can you see the full screen now?
Sir, it's not in the slideshow format, but the font is big enough for the audience to view the text in the slide, so that's all right.
Okay. Right. So in the fourth bullet point in this slide, what you see is that the public liability is not being seen except the liability imposed on the corporation to pay some compensation, right? Is that public liability conclusive, or should it also include the liability of the respective government, the state government and the central government, for not effectively supervising the factories, right, by the inspectors of factories and boilers, possibly that could have prevented this accident from happening. So therefore, it is a cumulative process of enforcing public liability, not necessarily that the compensation is given, that everything is wonderful and everything is fine, right? Can you see this change of slide? The third slide?
No, sir.
Yes.
You have to click. Yeah, now we can see it.
Okay, I think then I'll go through this process.
Yeah.
Right? So based on the previous slide, I have raised certain questions. What is the legal basis for remedy in cases of public liability, and who is responsible for that? Number 2, is there a constitutional basis for such a remedy? Or is there a statutory basis for such a remedy? Is the jurisprudence developed by the judiciary in this regard relevant and constitutional, both with reference to public liability and private individual liability? And finally, can there be a distinction for remedy based on the sovereign and non-sovereign functions of the state? And I'm taking clue from the tort law, where I think some of the states they are trying to escape by saying that we are exercising the sovereign function and therefore the government is not liable. Having raised these questions, we need to find some answer. Before that, I thought I will very briefly explain, not conclusively, but very vaguely, what these two phrases would mean: public liability in the first place and individual liability in the second place. Now, if you look at the first bullet point, public liability covers incidents in public places like slips on a badly paved walking path in a park, or when a motorcyclist or a scooterist driving through the roads in India, including the urban important cities, because of the pothole, somebody slips and falls. It is not his mistake. He has paid the road tax, right? But still he slips and falls and injures himself, right? Then it also covers many incidents that don't necessarily occur in a public place, such as dog attacks. And I hope all of you would have seen in the newspapers that a 7-year-old child was mauled by a bunch of dogs, 6 or 7 of them, right? And the child also died. In some other place the child is safe, but I think the injury is so bad it will take at least 3 to 4 years for her to totally come out of these injuries, right? And then injuries inside the aeroplanes, trains, and private businesses, to name just a few. So who is liable and what is the extent of the injury that we need to correlate? In the second bullet point, what you see is public liability can even cover an accident that occurs inside someone's home. Now, it is not taking place in India to that extent, but in Western countries it is possible. For example, somebody is inviting you for dinner. You go and sit in a chair and the chair breaks and the individual falls down, injures himself. Then the person, the host, is primarily responsible for this, right? Whereas in India, we don't even consider this as a liability. But the Western countries are able to take this because there is something called as insurance industry. And that insurance industry, when you take home industry, right? I'm sorry, home insurance, that home insurance also covers such injuries caused inside the residence of somebody's, home. And finally, if you see in the third bullet point, it is a legal responsibility to make financial reparation to a member of the public for death, injury, or damage to property caused by failing to take reasonable care in one's action. Reasonable care in one's action. And therefore, today in India, we have a statute called as Public Liability Insurance Act. I'm not getting into that act at all. But now there is a statutory response, a limited one, for this public liability. When it comes to individual liability, less spoken is better in India, because when an industry or when the government, somewhere the failure occurs, it is not the government or the institution, the legal personality cannot cause any damage, but it is the individual who is responsible for various positions, and they cause something, and therefore should they be made liable, right? And that is what is called as individual liability. One is the liability on the part of the institution, right? And that is what we call it as public liability. The other one is part of the individual who has committed this particular act. I'll give you a couple of instances to explain what it really means, right? Individual liability can be broadly defined as a legally enforceable claim on the government, company, corporation, or individual as liability results from a breach of duty or an obligation committed by an individual by an act or sometimes even failure to act. Therefore, it is primarily individual in nature. If the individual acts or fails to act as an authorized legal representative of government, company, or corporation, then sometimes it would be difficult to fix the responsibility on any one of the representatives of the government, and the liability is now taken over by the government itself. And therefore, where it is not possible or feasible for fixing the individual liability for the acts done or the violation committed, then the liability is now on the called as public liability, which will be with the company, with the corporation, or even the government, as the case may be. So therefore, it is a vague concept which is slowly emerging in the Indian jurisprudence. It has emerged, but it is not very clearly emerging as a distinct feature through any statutory law or through any of the constitutional provision. I'll also try to explain. I may be wrong in saying some of them, but still these things need to be understood in that particular broad perspective. Now, when we use in the title liability, sometimes we also interchangeably use the term accountability, right? Accountability, you may seek an explanation, and then once satisfactory explanation is given, the liability may not be there. That is also one way of looking at it, right? And therefore, sometimes, vaguely speaking, the students of law will also use liability and accountability as two interchangeable concepts. Whether they are right or wrong, we will try to explain. The second bullet very clearly says accountability is a form of liability, right? It arises from accountability is a form of liability that may refer to who and for what and what is accountable. So accountability broadly is a form of liability. Therefore, even when I use in this presentation, sometimes I'm also using it interchangeably, right? It is broadly understood as the obligation of the holder of trust to provide the accountability. The government, the companies and the corporations, and even community organizations at times are accountable to the public in general for something that happens, and what are the things that may happen, I'll try to explain as I proceed, right? Kernaghan, in his book way back in 1973, right, explains the problem in fixing the individual responsibility, and therefore we move towards public liability. According to him, the observation that I have quoted in this slide is very clear. It is frequently impossible to assign individual responsibility to public servants for administrative transgressions because so many officials have contributed to the decision-making process. I'll just try to explain with an illustration, with an example. I think if there is a custodial death or a custodial rape in a police station, right? There is a station house officer or station in charge police officer. Whether he should be made responsible, though he is out of that particular scene, right? Maybe when that thing happened, he was not present, he was on his other duty. Whether you can fix the responsibility on the station house officer primarily, or do you have to identify the responsible person who committed this offense, maybe an head constable, a constable, an assistant sub-inspector, whoever it is, who committed this offense, either the custodial death or custodial rape, and fix the responsibility on him. We are not clear. And above the station house officer, we have what you call it as the circle inspectors or the deputy superintendent of police, and the hierarchy goes on in the district. Therefore, to whom these people must be made responsible? Do you take the police station as an isolation incident and take those people responsible, or do you also include the police organization in its entirety in the district or even in the state and make the highest official take some responsibility for the offense committed against an individual within the police station? And that becomes a little difficult, little tricky. The allocation of responsibility in government has been complicated even further by the interposition of political appointees or temporary officials between political executives and permanent public servants. So it becomes much more complicated. I hope all of you would remember when the railway accident took place, the then railway minister Lal Bahadur Shastri submitted his resignation, right? He is the top political executive at that particular point of time as the cabinet minister of railways. And therefore, when the accident took place, more than 40 lives were lost in that accident. He took the responsibility on him and then submitted the resignation. When similar incident took place after 2 or 3 decades, to another railway minister, I don't want to name him, already he is facing the prosecution and conviction, so I don't want to name the individual. When he was the railway minister and the accident took place, the press people went and asked him, sir, in the previous instance, the railway minister resigned because of this accident and say around 40 lives lost. What is your action? What are you going to do? The minister responded by saying, that may be true. If I have to resign for this accident, then I think every day they'll be seeing a new railway minister. Maybe he was right, maybe he was wrong, but he was trying to explain that these things do happen and you cannot fix the responsibility on the political executives. I just try to give you an example through which the political executives can get away from that liability part of it and make the permanent public servants responsible for these things. I hope you understand what I'm trying to say. So Kernaghan was trying to explain that there is a series of hierarchy in civil service. It's very difficult to fix that responsibility who is to be made accountable. And when there is a political executive acting in consonance with permanent civil servants, then it is much more complicated. And therefore, they divide between public liability and individual liability, or public accountability and individual accountability is little complicated unless and otherwise there is a clear, or what you call it as, either the philosophy or the moral values which will take care of that. Like the example I gave you, Lal Bahadur Shastri took the moral responsibility, being the political executive, took the entire accountability or the liability on himself and resigned as the Union Railway Minister. But whereas in the other incident, the minister did not do it. Then automatically it goes to the person who is responsible for that accident, the manager in that particular zone, technical, whatever it is, and then you try to conduct an inquiry. After 2-3 years, when the inquiry comes to an end, people forget it and possibly their focus will be on something else. The entire process of accountability and liability gets totally diluted in this process. And that's what Kernaghan was very clearly mentioned in 1973 itself in his book. Right? Okay. Now, I would like to highlight a couple of constitutional provisions for public liability. Why do we sue the government? Right? On occasions, Union of India, we see these citations. Why do we use the government? Why should we? It is to bring the public liability to the extent that the government itself is responsible, and that is why we have this government held responsible. I would like to take you to Article 361 of the Indian Constitution, which very clearly says, Clause 1 says, the President or the Governor shall not be answerable to any court for the exercise and performance of the powers and duties of his office. Please carefully look at this. A president or the governor, who are supposed to be the chief executive, right, of the state and at the union level, shall not be answerable to any court for the exercise and performance of the powers and duties of his office, or for any act done or purporting to be done by him in the exercise and performance of those powers and duties. So it's a protection given to the president and the governor, right? Now, when the president and the governor, I think every action is done in the name of the president and the governor. If they themselves do something wrong, right? Even then, while they are in office, you cannot proceed against them, right? I will skip the first proviso given in Article 361, that is irrelevant in this case. Please go to the last point here in this slide. Provided further that nothing in this clause shall be construed as restricting the right of any person to bring appropriate proceeding against the government of India or the government of the state. So now what you see is, if something happens and the president does something and an individual and his right is violated, or an injury has been caused to him or to his property, right? You cannot take action against the president or the governor, but you can, and this is what Article 361 says, nothing in this clause shall be construed as restricting the right of any person to bring appropriate proceedings against the government of India if the president is responsible, as we have seen in Article 361 clause 1, or the governor in the state, right? You can sue them not directly against the president and the governor, but in the name of the government of India or the government of a state. This is the second proviso to Article 361. However, Clause 2 and Clause 3 speak about that no criminal proceeding can take place, he cannot be arrested as long as he is in office. But if you carefully read Clause 4 of Article 361, no civil proceeding in which relief is claimed against the president or the governor of a state shall be instituted during his term of office in any court in respect of any act done or purporting to be done by him in his personal capacity, whether before or after he entered upon his office as president or as the governor of such a state, until, see, there is something, until the expiration of 2 months next after notice in writing has been delivered. So you cannot take any criminal action against them. Civil action, yes, it is possible. And the only procedure that it prescribes is that you have to give 2 months notice, right? After 2 months notice in writing has been delivered to the president or the governor, as the case may be, or left at his office, stating the nature of the proceedings, the cause of action therefore, the name, the description, and the place of residence of the party by whom such proceedings are to be instituted, and the relief which he claims. So therefore, it is an important provision that we need to understand, that if the president discharges his powers and duties, and if there is some injury caused to an individual, for example, a road is being widened, or an airport is being constructed, right, or a flyover is being constructed, they have to demolish some of the properties of the individuals, right? It is in the performance of the duties of the president or the governor, as the case may be, but the injury is caused to the property of that individual. Therefore, what is necessary is some amount of compensation is to be paid. How will you proceed against? For this, I don't think you have to go to the president or the governor, right? But you can issue a notice, 2 months notice, and then you can proceed, and I think you can claim, even if the president or the governor is directly involved in that, and where they are not involved, you cannot identify, then possibly the liability is that of the government, which is called as public liability. Otherwise, it is called as individual liability. Now, having very briefly mentioned about Article 361, I would like to flag another issue which I think the students of law and the teachers of law should pursue whatever little they can do. Now, in the Constitution of India, Schedule 7, List 3, there is what is called as concurrent list. There is an entry 8. Entry 8 is called as actionable wrongs, right? Now, I don't know whether actionable wrong can remedy everything, but I think it can be a start off point. Unfortunately, right, it is 72 years after the commencement of the Constitution. neither the center nor a state has made any law for this actionable wrong under entry 8. I may be wrong. This is my understanding. If there is a law passed by any of the state, I only remember state of Karnataka way back in 80s, early 80s, trying to introduce something, but the bill failed because it was not taken up for consideration by the House and the bill lapsed automatically, right? So in my view, no legislation has been directly passed on this entry so far, right? But all the remedy that we see in this country, whether it is public or individual liability, it is done by the court occasionally, and the court does a good job, and sometimes it may not be. The Bhopal gas tragedy, as I mentioned to you, in my opinion, I may be totally wrong, in my opinion, the court could have made even the Union of India and the state responsible for not inspecting the factories properly and effectively to avoid what you call it as such an accident, right? So in spite of it, it is still the court which has taken certain decisions, and they have been moving in the right direction over a period of time, and it is time that we need to have some sort of constitutional as well as statutory requirement so that we are certain about what is to happen in the event of a liability, public or individual, right? Right. Having said this, what is the existing jurisprudence? Now, existing jurisprudence was wrongly developed, in my opinion. Once again, I can prove it, and that is not my intention today. Article 300, right, has been held as the basis for the tortious liability for the actions committed by the public servants, and the state is self-responsible, right? But I would like to just raise one objection to this, right? And this is what has happened in state of Rajasthan versus Vidyavati way back in 1962. Of course, nowadays the court is not referring to Article 300 in its judgment, probably for some other reason I do not know. But if you look Article 300, it clearly says the state may sue and be sued, right? And I do not know where the state may sue the individuals for any of these violations, right? In what context, whether we have a law at all or not, whether there is any precedent, I am not able to find any instance of such a thing. But the individuals have sued the state. The other way around, I think there are plenty of cases, which I am going to very briefly mention to you as I proceed. So therefore, the question or the questions for analysis for this presentation is, what is the relevance of Article 300 in these cases? I am just raising this question, keeping in mind a couple of slides prior to this. I made a mention about entry 8, right? Entry 8 is very clearly there, and no law has been made, and therefore, can we rely upon Article 300 as the basis for all these public and individual liability? In my opinion, the answer is no, right? So therefore, analysis that we need to look at is, what is the relevance of Article 300 in such cases? If it is not relevant, if it is relevant, that's a different story. Then I will go to the other part of my presentation, which I'm not doing it today because I require at least 2 to 3 hours to convince you, right? And therefore, if it is not relevant, then which provision or provisions of the Constitution or any law that could be relied upon for tortious liability of the state, please ask this question and try to find out whether we have a constitutional provision or a law for enforcing this public liability or the individual liability. I think then you will get the answer, right? Or second question, should we rely only upon the precedent, the decisions of the court, right? And then the decisions of the court, it takes long period of time. Sometimes it takes years together for the court to decide. And now the people also go from one court to another till they go to the Supreme Court. They are not satisfied. So it may take even longer time. And number 3, why should the state pay if the tort was committed by its servants that are not authorized? And that is the place where I would like to bring in the concept of individual liability, or what I have presented here as personal officer liability. I hope you are able to follow what I am trying to say. Through this analysis, we are trying to find out whether a distinction could be made between the public liability and then the individual liability. The purpose of making individual liability is to fix the responsibility on the civil servants or the public servants, right? So that the state is unnecessarily not paying the compensation for the errors committed by the civil servants. And there are plenty of cases. I'll come to that as I proceed. And therefore, if you fix the personal officer liability, such mistakes cannot be committed at a later point of time, and the public liability, which has been ruling the rules so far, possibly can come down. That's my expectation. I may be wrong, but anyhow, let us see. What is this personal officer liability? I would like to just mention way back in 1989. Please carefully follow this instance because I'm not able to put all these facts in this slide. In 1989, Justice Mohan was the Chief Justice of the Karnataka High Court, who went to the Supreme Court later. He is no more with us. And in 1989, it so happened, the brief facts of the case, that a rich boy fell in love with a poor girl whose parents were daily wage earners, right? The girl was looking very beautiful. They fell in love with each other. And one fine morning, the girl was not there at home. I'm sorry, the boy was not there at home. And the parents got worried about it. They went to the police station and they also knew about it. And the sub-inspector of police straight went to the house of this girl. And the girl was also not there. And therefore, he picked up the father and mother of the girl and brought them to the police station. And he kept them in the police station for almost 2 days. Right? Some of the NGOs who got to know about this straight away moved the Karnataka High Court for habeas corpus. And the Chief Justice, and along with another judge, a division bench, which listened to the petition, directed the sub-inspector to produce the parents in the court of law. And then the sub-inspector was asked to appear before the court. When he appeared, I think he did not appear on the first day. Notice was served. And then on the designated day, he did not appear. But knowing these things, he relieved them or released them on the second day. But the fact remained that they were in the police custody. Of course, the police took care of their needs, like giving them lunch, dinner, whatever it is. So after 2 days, they released them. And there was not even a single document recorded by the police. Right? Now, when this issue came and the sub-inspector was asked to appear before the same court, same bench, he appeared. And then, he was not able to explain the reasons as to why he picked up the parents, because the parents did not do anything, right? He was not able to explain, and the judges were very furious that under the Constitution there is a protection. No person can be arrested or detained for more than 24 hours. If they are arrested within 24 hours, they must be produced before the nearest magistrate. And where are the records? When did you arrest them? Where are the records? Before which magistrate you have produced? You was not able to produce any of those records. Now, can you make the state responsible for the mistake committed by the station house officer in this case? Because there is also one more case which was decided by the Karnataka High Court few years ago. There was a superintendent of police, right? I'm now comparing both the cases. Then you will appreciate what I'm trying to say. There was a superintendent of police. There was a custodial death. And then the superintendent of police was not even responsible, remotely responsible, right? But it happened in a police station. There is a station house officer. There is a circle inspector. There is a deputy superintendent of police, additional superintendent, then finally superintendent of police, right? In this hierarchy, the court said, you are responsible because you have the authority to supervise the entire district. and this offense was committed in your district, and therefore you are also responsible, and asked the superintendent of police to pay a compensation of 2 lakhs of rupees to the deceased family from out of his pocket. Because the moment such an order is issued, the order is passed on to the government will pay 2 lakhs and the individual keeps quiet. But this time the court very clearly said this amount has to come from his pocket, from his salary, and he has to compensate that the individual's death by giving money to the family members. Right? Now you see, it happened in a police station. It crossed 3 or 4 levels. It comes to the level of what you call it as superintendent, who has the authority to supervise but failed in his duty to supervise, and therefore he was held responsible. He went on an appeal from one court to another, and finally the Karnataka High Court affirmed the decision and said he has to pay the compensation. So in this case, in the case that I am referring to, the first case, when he was not able to produce, I just wanted you to carefully look at the order passed by the Karnataka High Court in this case. Number one, that the sub-inspector of police who is responsible for the arrest and detention of the parents of the innocent couple for 2 days in the police station was violating the constitutional right given to the citizens of this country. Number two, as they are wage earners, daily wage earners, the sub-inspector of police prevented them from involving or getting into some avocation through which they can earn the bread. Number three, therefore, the sub-inspector has been asked to pay 2,500 rupees. It looks little smaller amount, but that was the salary some of the teachers were getting, in 1980s. So therefore, 2,500 rupees fine has been imposed by the court on the sub-inspector. Number four, this fine has to come from the sub-inspector himself. The state will not compensate. Number five, the treasury, the disbursing officer was given the direction to deduct this 2,500 rupees in his salary in whatever way he says, put it on record and send this record to the High Court. Number six, that the superintendent of police was directed to make necessary entries in the service book for the violation of these, rights of these individuals, and a sort of black mark in his promotion and other avenues. So 6 important features have been developed by the court. There was no law, gentlemen. There is no law, ladies and gentlemen. But still, the court went on to say that the personal officer liability is very squarely fixed, and then this is how it is to be done, and the state need not come to the rescue. Right? Therefore, you slowly started evolving in the place of entry 8 of list 3 of the 7th schedule, which has not been translated into any law, any piece of legislation, either by the center or the states, right? Except that insurance, that law that I mentioned of 1993. Then comes the statutory provisions. 2 references I am making. The first one is Section 20 of the RTI Act. Gives the judicial decision, right, or the judge-made law, a statutory support, right, by incorporating Section 20 of the Right to Information Act 2005, that the Central Information Commissioner or the State Information Commissioner can impose a fine of rupees 250 per day till the information is furnished by the APIO, etc., for not providing the information or provides insufficient information, and the fine can go up to a maximum of 25,000 rupees. Now, these 25,000 rupees, the PIO has to pay. It is not the government which has to pay, not the public authority which has to pay. It has to be paid by the public information officer, which is also, in my opinion, maybe the first personal officer liability that comes into picture with the statutory approval. The second one is under Section 138 of the Companies Act 2013. The director of the company is also made personally liable for certain offences. I am not getting into the details of that. Are you able to see the change in this slide?
Yes, sir.
Okay. Chairman Railway Board versus Chandrima Das. I don't want to make this into a tort class, right? Law of torts class. But you see this, the judgment of the court, right? Very clearly saying that compensation has to be paid by the railways because the servants who were violating the freedom of that individual, a foreigner in this particular case, the state was held vicariously liable, and then on the principle of strict liability. This is an instance where the public liability once again comes into picture. Neelabati Behera versus state of Odisha is another case, which is a wonderful case. I think no court worth the name anywhere in the world has done such a thing. In the presence of the reservation by India on Article 9, Clause 5 of the ICCPR, the court went on to say, we have already created the precedent of giving compensation as part of public liability, and therefore we are not bound by the reservation that the government of India has on Article 9.5 of the ICCPR, and went on to provide the necessary compensation, right? And then comes a very important development, the Protection of Human Rights Act 1993, right? Even before it was molded in the form of a law in early 94, it was through ordinance the NHRC was set up, and then somewhere in December 1993, an incident took place called as Bridge Behera incident, popularly called as Bridge Behera incident, where some around 44 people were injured by the atrocities or the actions taken by the army, and then it has to act through the Ministry of Defense, and the NHRC worked, and finally it was successful in getting what you call it as the penalties awarded in form of compensation to the victims of torture, custodial rape and custodial deaths by police and paramilitary forces over a period of time. And two of the security forces were also given the punishment of reduction of rank. So now you can see there is a mixture of individual as well as collective liability. When the individual responsibility cannot be fixed, then you can speak about the collective responsibility, or what you call it as public accountability. Right. Now, if the judiciary has done more than what it is required so far, should it keep quiet? Should the courts continue to develop the concept of personal officer liability and make them personally liable to pay the compensation amount from their pocket, right? Sometimes, as I explained to you, one or two cases, there may be few other cases, then possibly the administration can be streamlined to a great extent, right? For everything, if individual liability is converted into public liability, I think the administration is not going to learn any lesson, and they will continue to commit these violations time after time, and therefore public liability cannot be the right recourse that the individuals should face in a democracy like ours. And should there be a law for effectively bringing this personal officer liability in administration, so that the public liability can be reduced to a great extent, make the individual officers liable and responsible so that they will not commit these mistakes again. In my opinion, the sub-inspector of police who was imposed 2,500 rupees as compensation to be paid to the couple, I don't think he will do that next time. Even if his superiors order that, he may not do it because he has already burnt his fingers. And that is what is required in this country to strengthen this concept of personal officer liability through law. And through law, when it is done, it is still possible for the courts to add some jurisprudential inputs to make it much more meaningful and broader. Right. Having said this, I will not get into the details due to paucity of time. There is a dilution of Article 300. Nowadays, the court is not using Article 300 as the basis for compensation. Therefore, I will just skip these things, right? And then move on to what I would like to say and conclude this brief presentation, right? These are the things which I wanted to discuss, but I think I will avoid these arguments, right? Right. Now, coming back to, I'm just, I have skipped 2 arguments. So let me just continue with the argument number 3. Assuming that Article 300 is not the constitutional basis for tortious, assuming, because the courts are now not invoking Article 300, right, is not the basis of tortious liability of the state, then is there any other constitutional statutory provision? We need to look at it. I have already mentioned some of them to you. Was the court right in relying upon Article 300? Right? If the court was wrong, what can be appropriate provision of the Constitution? I will once again look into those arguments which I presented to you earlier. Article 361, right? The provisos, and entry 8 of list 3, right? Okay. The last 2 slides very quickly, let me just complete. Liability in modern government. Accountability and liability lie at the heart of any democratic governance, and India is no exception to this, right? Now, recently, if I remember right, somewhere around 1990s, mid 1990s, the UK government, the Institute for Government, has studied accountability in modern government and observed the following. I just gave 4 important points or features of this report. What is it? The first one, a strong accountability matters, and when it works, it benefits everyone. So they are also arguing for strong accountability. It really matters in administration, and what it works, and when it works, it benefits everyone, right? Second, it enables people to know what the government is doing, and that is the purpose with RTI also, which came into rescue to some extent. Number 3, it ensures that the ministers and civil servants are acting in the interest of the people they serve. Very, very important, right? If somebody is dying in the prison, right, or a custodial rape is taking place, right, they are certainly not acting in the interest of the people they serve. They are acting against it, rather. But it ensures that they serve in the larger interest of the people they serve. And finally, accountability is a part of good governance. Please keep this in mind. Accountability or liability is a part of good governance, and it can increase the trustworthiness and legitimacy of the state and government in the eyes of the public. These are the 4 important observations made in that report, and what it said in UK, right, equally applies in this country. Let me tell you, there the individual liability, right, is much stronger than what we have, because they have certain rules, regulations, and laws, but we don't have any except those judicial decisions. Right. Now, concluding slide. While strong accountability is not a panacea for solving numerous challenges that the government faces in complex environment, and particularly like that of ours in this country when compared to UK, but certainly it can improve governance, and that is the objective, right? And the concept of good governance is gaining significance in the last 2 decades or even more, and therefore we need to improve the quality of governance, and therefore a healthy system of accountability that promotes, right, improvements in governance, and it should include the following 4 important features. This is also based on the report, the UK report, so it is not my contribution. I am only saying that this is the suggestion made, or recommendation made in that report. What is that? You have to inculcate proportionate rewards for good performance of civil servants. Maybe in England it is possible. Occasionally, it is also possible when the President Meritorious Service Award is given, right? And some police officers and civil servants even general public, they are all given some awards and rewards. It is good. But proportionate rewards for good performance, I think we need to work in a better manner so that we identify the good performance and reward them to improve governance. That is the objective. Not to promote some individual, but to improve the performance of the government. Second one, if you are talking about rewards, the report also recommended proportionate sanction for failure. I think this is the place where we also fail. The moment you impose a proportionate sanction, right? I think we have got too many levels of judicial system. They go to the city court, from there appeal, then second appeal to the High Court. And if it is a single judge, then it goes to a division bench and then to the Supreme Court, review petition. I think by the time the action is taken against the erring civil servant, possibly he or she may even retire from the service. So that proportionate sanction for failure needs to be fixed, and we need to do a little bit of research and see to what extent this can be brought in as part and part of civil service rules. If it is already existing, why it is not functioning effectively. The third one is a greater degree of learning than the present one. Right? It is, see, the objective, greater degree of learning than the present one, which means we also, they want to analyze it, read it properly, and then improve the standards. And finally, support for responsible individuals to develop so that they are able to innovate and take appropriate risks. Now, with these 4 recommendations, which are very, very relevant even to the Indian administration or governance, whatever we have, in whatever name we call, I would like to conclude with one statement, which evolved in French system of administration, that higher the rank, greater is the penalty. Needs to be integrated in administration so that individual liability gets strengthened, public liability gets strengthened, and good governance emerges out of these 2 liabilities that we have been talking about over a period of, say, the past 40-45 minutes. Right? Now, higher the rank, greater is the penalty, is what I mentioned, the second instance of Karnataka, where the superintendent of police was not even present. Right? He was not even in the district. But still, he was made responsible for the custodial death and was forced to pay 2 lakhs of rupees as a personal liability, because the court very clearly pointed out, as the chief of the entire district police force, you have failed in the ongoing down the line supervision. I hope you understand what I'm trying to say. Ongoing down the line supervision. And therefore, the person who commits the error may be imposed to 2,500 rupees or 5,000, 10,000, whatever it is. But the higher ups must be imposed much higher penalty so that there is an effective supervision, and that supervision is not on paper, but ongoing down the line supervision. And if that is possible for us to realize in this country, then possibly both these liabilities that we have been talking about, or accountability that we have been discussing, both of the government, for everything you don't have to go to the government, fix the responsibility on the offender, civil servant or police officer or whosoever it is, and make him responsible for that, fix that responsibility, impose a penalty, reduce the rank, do whatever it is, then possibly we can see the concept of governance becoming good governance over a period of time. Before I say thank you, if there is a district in this country, anywhere in this country, there are what you call it as looting taking place left, right, and the center, or greater number of rapies taking place, or greater number of instances of child sexual offences taking place. Is it possible for us to say and fix the responsibility on the head of the district that you are primarily responsible, you are not able to supervise and get the law implemented, get the judgment implemented effectively, and therefore you will be responsible for all these things happening in that particular district, fix that responsibility on that individual superintendent of police or whosoever it is, or the collector of that particular district, then I think the entire edifice of governance will change, right? We are not doing that. And when we try to do that, ultimately the state or the individuals or the officers, they also go to the court, and the entire process gets delayed. And then, as I mentioned to you, there are cases where the individual officer retired, but the case was still going on. But in this regard, I also wanted to flag one important judgment of the Supreme Court, which comes very handy. That is Deputy Director Collegiate Education versus Nagur Mira, 1997 judgment of the Supreme Court. Please read the judgment, right? If there is a prima facie case and the officer is convicted in the first level, the officer stands suspended or dismissed from service, right? Or you can still want to keep him on roll, keep him on roll. Let the appeals go on, and finally, till it is decided by the Supreme Court, don't bring him back to the civil service, right? But nobody knows about it. After 6 months, they say that under the civil service rules, they have to be posted back. They are posted back in the same position. Maybe there is a slight change in the office. This type of things we need to stop and contribute to what you call it as the good governance element in this country. Ours is a much more complicated country when compared to England. Their suggestions and other things may work there, but we need to work much more to see how it could be refined and contributed towards what you call it as the good performance and effective performance of civil servants and also the government at the higher level later. I'll just stop here. I think I have taken 1 or 2 minutes more. My apologies. If there are any questions I do not know, I can respond to that question little later.
Yes, sir. Thank you so much, sir, for that extremely enlightening and insightful session. There aren't any questions in the chat box, so I'll pass it on to Professor Chengappa for his comments and observations.
Sir, with your permission, just may I ask one opinion, your opinion, sir?
Yeah, please go on.
Sir, it has been commonly been argued that with the globalization, the state role is diminishing day by day.
Yeah.
So, sir, as a student, I want to know your opinion that are we jurisprudentially enriched enough to deal with this issue?
Now, that is your obligation. See, we are in the 11th hour of our life, right? It is the youngsters like you to do research, and that is the very objective of this presentation, right? That is the very precise purpose for which this presentation is made. We need to reinvent our jurisprudence, right? And make both of them simultaneously present. I think the amendments made to CRPC recently, right? That for the rape committed by somebody and where the individual is not identified, you look at the victim. And now for the victim, there is a compensation. That's not least a new change which has emerged. So like this, we need to look at where the individual responsibility can be fixed, fix it and quickly enforce it, right? The judicial process is taking longer time, and therefore everyone is taking what you call it as protection under this procedure, and they are very happy. Once you go to the court, okay, you go to the court, 30 years, 40 years it will take, I'm not worried. That has to come to an end. So therefore, a stipulation of period, maybe within a year or two, it must be disposed of. I think these things may make the governance accountable and more responsible, right? And civil service also need to be trained. I told you, this last slide, which is still being shown, right? Rewards for good performance and sanction for failure has to be there. If that is not there, I think any civil service will not come out effectively.
Thank you, sir. Take my regards.
Thank you.
Thank you very much, sir, for your insightful session. You have discussed about all the trajectories of the development with respect to public liability and individual liability. I still remember Captain Satish Sarma case where Satish Sarma had to pay 50 lakhs rupees from his pocket.
Yes.
Similarly, when we look at the Article 311,
Yeah.
Government of India have been given so much of the power to issue rules and regulation under the service matters, but
Yeah.
we don't find the
Exactly.
individual liability have been imposed. Everything falls within the purview of public liability.
Yeah.
Money will be paid from the public exchequer rather than from the pocket of individual, the officer. I think there is a need to focus from public liability to individual liability in order to fix accountability in the system. I think we need to further develop this common cause versus Union of India, Captain Satisama case. That is really one model.
Well said, well said.
I will give final word to our VC sir. Sir, you are mute.
Sir, your mic.
Good afternoon, Professor. Thank you
good
for
afternoon.
your valuable comments and focusing the need of the time. Definitely students and few faculties, they will look, at least if not on their own, they can insist their scholar to do on this area research, and definitely it will be some insight to be and food for thinking for the near future. Thank you for joining.
Thank you, thank you.
Thank you.
Hello, sir.
Yep.
Lordship will join within 5 minutes. Please, you people carry on.
Right. If
any question?
Chakrabarti,
I'm
permits.
audible.
Yes, ma'am, you're audible.
Okay.
Okay, ma'am.
Varuna, any questions?
No, sir, I don't have any question.
Then Dr. Chakrabarti, can I just take off? I have to go for my lunch.
Yes, yes, of course.
Thanks a lot. Thanks a lot for giving me an opportunity.
Thank you, thank you.
Thank you so much, sir.
Thank you, sir.
Bye.
Thank you.
Bye.
You're welcome. Yeah.
So, Chengappa, collective responsibility is no responsibility at all.
Collective to it is a transition from collective to individual. So now connect Honorable Justice Banerjee.
Yeah, she will join.
She'll be joining in 5 minutes.
Achha, okay. Continuously from yesterday 10 to almost 4, except lunch. Thank you the whole team to continue this long session. And only
PhD batch students also joined, sir. PhD batch student 2020 and 2021 also.
Okay. And now this session, Chingappa and his team organized, I think 4 or 5 programs already. Maybe before end of the semester, another one, and he has been given permitted to have wetlands study also with the students. Very good, I think, opportunity. Whether in any physical program in March end, let us see.
Yeah. Now we have to go for both hybrid modes, sir.
Hybrid, yes.
Some guest can join both. Online and
Some
offline.
guests would be, but the audience would be in our campus.
Yes. How many students are that?
Justice Bose yesterday called me. What I will tell? From books, theory, or what? I told you speak on your experience better instead of going to theory. Justice Banerjee. Good afternoon, Justice Banerjee. Professor Chakraborty here.
I recognize you.
Okay, sir. Okay, madam.
Good afternoon.
Good afternoon.
Let me warn you one thing.
Huh.
The connectivity, internet connectivity at my end is not up to the mark today. From yesterday evening onwards. So let us
hope it will be at least for 1 hour. It will give us some relief. So quickly you start the program.
Very well. I wish you all a very good afternoon, and it's a pleasure for me to be here. As you are aware, I was associated with the university as a member of the governing council and the executive council before my departure from Calcutta, and maybe for a year or so afterwards.
Yeah.
Yes. And I'm really happy that the university is conducting a seminar, conclave, on a very, very important issue. As we all know, that with the expanding socio-economic functions of the state and the increased powers of the government, administrative law has assumed immense importance. Administrative law is that branch of law which regulates the functioning of the government and governmental agencies, both at the central and at the state level and elsewhere. The concept of governance is as old as civilization. What is governance? It simply means the process of decision making and the process by which decisions are implemented. With the transition of the state from the laissez-faire state to the welfare state, the activities of the government have increased manifold. As we all know, the government today is regulating healthcare, it is regulating education. You just name the sphere of activity and you find the presence of the government or governmental agencies, the statutory authorities, the corporate bodies. Now, what is governance? As we said, it is decision making and the process by which decisions are implemented. The concept of governance is as old as civilization. The quality of governance depends on a large measure upon how the subjects are treated. The quality of the governance depends on how the rulers treat their subjects. According to ancient Indian texts, such as the Dharma Shastra, the duty of the king is to ensure the rule that he is guided by the rule of law in every decision, big or small, and such rule of law is enforced through a system of good governance. Good governance is exercise of economic, political, and administrative authority to manage the affairs of the country at all levels. It is a mechanism of processes. The concept of governance is broader today than the concept of government administration. Governance, when we talk of good governance today, we do not just talk of administration by the government agencies. It includes governance by corporate bodies, both in the government and in the private sector.
I think there has been internet connectivity issues at her end. Let's wait for her to reconnect.
Without introduction or anything, I just asked, and I thought you will take up and then Madam will start. But Madam started. So after
It's all right.
lecture, we can finish the thing.
It's all right.
For that, offline is the best system.
Correct.
Both in class or any program. Though the only one thing is advantages for some international speakers.
Yes.
We have to arrange, we have to pay, they will come, and normally they are not allowed during their session to come, but we can get. So hybrid is okay, particularly resource persons in between the physical speakers, we can have one.
Yes.
I'm extremely sorry for the at this end.
We understand it may happen sometime.
Yes.
Okay, madam, continue.
We were talking about the expanding functions of the state. With the expanding socio-economic functions of the state, the increased powers of the government, administrative law has assumed immense importance. The transition from laissez-faire to the welfare state has widened the sphere of governmental activities. Administrative law is that branch of law which regulates the functioning of the government and governmental agencies, both at the central and at the state level, and at various other levels. To put it in one word, it is governance. The concept of governance is as old as civilization. What is governance? Simply put, it is the process of decision making and the process by which decisions are implemented. The quality of governance depends, in a large measure, upon those who govern and the treatment of those who are governed. I will make some reference to some of our ancient texts. What does the Dharma Shastra say? The duty of the king is to ensure that he is guided by the rule of law in every decision, big or small. And such rule of law is enforced through a system of good governance. So we see the origins of rule of law in our ancient treatise. It's not something which is absolutely new. Nowadays, of course, when we talk of governance, we not only talk of the role of the government, particularly in the context of good governance, we talk of sustainable government. We talk of government companies, statutory authorities, civil society, the private sector. The responsibility for managing the affairs of the nation is not restricted to the government alone today, but to the various stakeholders, the corporate bodies, both government and non-government organizations, the media, and members of the civil society. The concept of governance focuses on institutions and processes. Priorities need to be determined through processes which involve all the stakeholders. In other words, it takes into account the views of all concerned, including those who are governed, those for whom there is governance. The subjects are as important as the rulers in the process. Transparency in decision-making processes has the potential for improving the quality of overall governance. Good governance is the way in which administration improves the standards of living of the people by making the basic amenities of living available to them and by ensuring their safety and their security. What good governance aims at is sustainable development. Good governance endeavors to improve the future and ensure that future generations do not suffer by reason of the mode of governance at present. Thus, good governance focuses on preservation of ecological balance, environment, and preservation of material resources. Good governance should aim at preservation and improvement, let us say, of the soil, so that future generations are not denied food. According to the United Nations Commission on Human Rights, the key attributes of good governance include transparency, responsibility, accountability, participation, and responsiveness to the needs of the people. Good governance means creating an environment which facilitates the enjoyment of human rights and promotes human development. Equality before the law is the basic requirement, in my view, of good governance. Good governance may be summarized as what Kautilya said in the Arthashastra. The pleasure of the king lies in the happiness of his subjects. He should do what is beneficial to him alone, that is the subject. He should not do what is beneficial to him alone. He works for the benefit of the public. Good governance includes in its fold a strong, independent, efficient judiciary. Again, I refer to an ancient treatise, the Shukraniti, which says, a person who is proficient in civil and criminal law and procedure, happy-minded, impartial to both friends and foes, followers of righteousness, sober in speech and behavior, fair, may be appointed judge irrespective of caste. Now, when we talk about the judges, we'll come to it a little later perhaps. We don't talk about the judges of the courts of law alone. You also have judges of tribunals. You have judges who function various quasi-judicial functions. Only those persons should be appointed judges who are honest, truthful, ethical, impartial to all, foes, friends, the rulers, and the ruled, knowledgeable, so that they may discharge their judicial duties properly, without fear, without favor. As per the oath of office, which judges usually take. Expeditious delivery of quality justice is the need of the day. Judges, whether of courts or other tribunals, should remember the caution in the Shukraniti. What does the Shukraniti say here? Decision of cases should not be an outcome of anger or greed, but should be based on righteousness. As per the treatise, judges have to be cautioned from 5 evils, which are attachment, temptation, fear, malice, and interestingly, secret meeting. What is secret meeting? We all know today that judges hear cases in open courts, whether it is a judge of a court of law or a judge of a tribunal. He does not meet any of the parties behind the back of the other. He does not discuss a case behind the back of others. A very basic requirement of judicial ethics. Human rights are those rights which may legitimately be claimed by a person by virtue of being born a human being. Human rights are as old as civilization. What are these rights? It is the right to live. What kind of life? It is the right to live a life of dignity, which includes the right to food, the right to shelter, the right to clothing, the right to health care, the right to education, the right of personal liberty, so on and so forth. The right not to be tortured, the right not to be treated arbitrarily, the right not to be discriminated. After all, what can be more humiliating than discrimination? These rights have been enumerated in the Universal Declaration of Human Rights, which was adopted by the United Nations on 10th December 1948. And they have been followed in a plethora of conventions and international arrangements. Let us say the Convention on Elimination of Discrimination against Women, which is often referred to as the Bill of Rights of Women. You have the conventions which take care of the rights of children, the rights of the differently abled. So these are all different forms of human rights. And in governance, these rights have to be kept in mind. These rights have to be implemented, upheld, and enforced. In India, we have a constitution. The preamble to the constitution itself guarantees to all its citizens justice, political, economic, social, economic, and political. Liberty of thought, expression, belief, faith, and worship. Equality of status and of opportunity, and to promote amongst all fraternity, assuring the dignity of the individual and the unity and integrity later added by the 42nd Amendment of the nation. The people of India constituted themselves into a sovereign democratic republic. To sovereign democratic were added the words secular and socialist by the 42nd Amendment. This is what the Constitution promises the people, and this has to be upheld. We have the fundamental rights which are basic in the governance of the country. In India, the Supreme Court has expanded through judicial decisions, through interpretation of Article 21, the scope and ambit of Article 21 of the Constitution of India. The right to live, or the right not to be deprived of his life or liberty without authority of law, has been interpreted in a purposive manner in a liberal manner to ensure that a person is not deprived of his right to live with dignity. And any law which is arbitrary, which seeks to deprive a person of human rights, would be violative of a fundamental right and therefore unenforceable. There has been shift in the judicial thinking. Initially, the fundamental rights were compartmentalized, and Article 21 was given a narrower interpretation to mean that a person could not be deprived except in accordance with law. But in the case of Maneka Gandhi, there was a complete change, a widening of the sphere. The court would be entitled to look into that procedure, to look into whether the procedure was arbitrary or not. Now we come to Article 14. In Article 14, we find the roots of the rule of law. Everyone is equal before the law, and the law has to be applied equally to all. When we talk of the expression rule of law, we mean the supremacy of the law. Where there is rule of law, no person can be said to be above the law. Governance must be in accordance with the law and not as per the wishes of the rulers. It is the principle of constitutionalism, where we respect, uphold, and abide by the Constitution. To quote Max Weber, legal domination as the idea of government is the idea of government of law rather than idea of men, government of men. In a sense, the rule of law means that everyone from the government and its officials to the citizens should act in accordance with law. The law is binding on all, everyone is governed by law, be it the rulers, be it the rules, the subjects, everyone. All citizens have a duty to obey the law. But to enforce obedience of the law has to be just law, not law which is arbitrary or oppressive. The expression rule of law is derived from the French phrase le principe de l'égalité. In English, the expression means principle of legality. Professor Wade said, the rule of law requires that the government should be subject to the law rather than the law subject of the government. The rule of law makes sure that the executive does not use the law of the land to oppress or curtail freedom of individuals as guaranteed by the Constitution. The expression rule of law is not used anywhere in the Constitution of India. However, the Indian courts have time and again referred to the expression, the rule of law. So rule of law, which is very very much part of the Constitution, though the word may not expressly have been used, has been developed. The concept of rule of law has been developed and explained by various judicial verdicts of the Supreme Court. In India, we do not go by the maxim that the king can do no wrong. It has no application. All public authorities have to abide by the laws. Now, when we talk about administrative law, which has grown in a way, it is a set of rules of governance. It involves various administrative decisions. It also involves decisions which affects the rights of citizens. It involves decisions which may have civil consequences. Let us say the implementation of an expropriatory law, an administrative action for misconduct. Now, it is well settled that a decision which has prejudicial consequences on a citizen has to be in compliance with the principles of natural justice. Natural justice is actually common sense justice. There are no uniformly defined rules of natural justice. Therefore, this is also a growing area. It is expanded and it is also limited by various judicial pronouncements. There is no uniform law saying that in all cases this has to be done, but it depends on different statutes. It depends on the facts and circumstances of a particular case and the applicable law. The expressions natural justice and legal justice do not present watertight classifications. Deprivation of a person's legitimate expectation also attracts the principles of natural justice. Now, we all know the basic rules of natural justice. Nemo in propria causa judex. No person should be made a judge in his own cause. The judge should be free from bias. A judge must be impartial. The judge must decide the case objectively on the basis of the evidence on record. A predisposition to decide a case for or against one party without regard to the merits of the case is bias. And that is a complete no. This applies to the judges of courts, and this applies to the judges of tribunals and those charging quasi-judicial functions. Whether the bias is conscious or unconscious, it is to be frowned upon, deprecated. It could be a preconceived opinion or a predisposition to decide in a particular manner. Anything where the any situation where the mind is not open militates against the concept of fairness of adjudication. In Crawford Bailey versus Union of India, Supreme Court said the doctrine of rule of bias comes into play if it is shown that the officer concerned has a personal connection or personal interest or has personally acted in the matter concerned or has already taken a decision one way or the other, which he may be interested in supporting. Now, this rule of disqualification of a judge who has a personal interest is to be enforced not only to ensure that a decision is not partial, but this is also to ensure that people have confidence in the manner in which the decision has been taken in the administration of justice. After all, if a judge were to personally know a party before him, let us say a judge of a tribunal, the losing party might legitimately think that the proximity of the judge has influenced the decision, even though the judge may have done what he actually thought was right. The Supreme Court has time and again held that a decision which is the result of bias is a nullity, and the trial is coram non judice. Inference of bias can only be drawn from facts and not on the basis of suspicion, on the basis of insinuations, conjectures, and surmises. You have to show that there is some kind of real interest so far as the judge is concerned. There are also exceptions to the rule of your nemo judex in causa sua. And this is a case of invocation of the doctrine of necessity, where there is no other authority there who can take the decision. Was evolved by the Supreme Court or recognized by the Supreme Court in the Subramaniam Swamy case, the election commission case. Therefore, what are the various forms of bias? Bias could be personal bias, pecuniary bias, subject matter bias, the inclination to decide a particular thing in a particular way, departmental or institutional bias, preconceived notion bias, bias on account of obstinacy. How these would be dealt would vary from case to case, depending on the situation. In issues relating to administrative decisions, what exactly is the scope of interference? Now, all administrative authorities, all courts, all tribunals have to decide within the limits of their jurisdiction. Whether it is area jurisdiction, territorial jurisdiction, subject matter jurisdiction, pecuniary jurisdiction, so on and so forth. Now, the courts are called upon to decide when there are allegations of errors of facts or of law committed by these administrative authorities. The doctrine of ultra vires and the doctrine and the principle of objectivity are important issues over which the courts supervise, which the courts implement. Very often, administrative authorities have wide discretionary powers. Now, to what extent can the courts interfere? All discretionary powers have some objective limits. But where does the problem lie? The problem lies in identifying the limits. Let us say there is a law under which a particular authority decides that a foreigner should be deported if he does not have a passport, if he does not have a visa, etc. Now, that authority has the jurisdiction to take the decision to deport. But the exercise of his jurisdiction would depend on whether the person who is being deported is a foreigner or not. And if it is to be found that if he is not a foreigner at all, that would go into the root of the jurisdiction of the authority concerned to decide. Now, so far as discretion is concerned, the courts would not ordinarily interfere with the decision on merits. Discretionary power includes the power to decide freely. These courts do not generally sit in appeal over whether the decision is correct or whether the decision is wrong. But the courts examine the decision process, the process by which the concerned authority has taken a particular decision. Until some time ago, it was thought that there was a liberty to make mistakes within jurisdiction. And this liberty extended to mistakes of law and to mistakes of fact. But today, these have been brought within the scope of judicial review. An authority exercising jurisdiction is required to comply with all requirements for exercise of jurisdiction. The principle of objectivity requires the courts to define that area of freedom. The court is bound to prevent serious usurpations of power. To quote Professor Wade, the object of the courts is to prevent this at all costs by standing guard over the frontiers of discretion. In other words, to quote Professor Wade, the minister or other body must not be allowed to be the judge of the extent of his own powers. The courts set the limits. However, this area of jurisdiction is a hard-worked word. Commonly, it is used in its broadest sense, meaning power, the power to exercise. In some contexts, it would bear the narrower meaning of power to decide or power to determine. But there is really no technical difference. Except where there is an error on the face of the record. The principle that is at work is that the courts do not interfere when a decision is taken within jurisdiction. Today, by judicial pronouncements in India, a perverse decision, a decision which is not based on any materials on record, is to be interfered with. The administrative authorities are to be set right. A decision which is totally arbitrary, which is totally unreasonable, which attracts the Wednesbury principle, may be interfered with, even though the decision may be an administrative decision. When a jurisdictional question is disputed, the tribunal must necessarily decide the jurisdictional question. If it refuses to do so, it is wrongfully declining to exercise jurisdiction. The courts would interfere. If the courts do not, then the authority would be able to wield absolute power, which the legislature never intended that it should exercise. A question may be within the tribunal's jurisdiction. The question of whether the tribunal has jurisdiction or not. Now, this is a very tricky area. The court can go into jurisdictional facts. The court can examine jurisdictional facts to ascertain whether the tribunal, whether the administrative authority had the discretion to take a certain decision or not. But there again, what happens if the facts are disputed? Let us say there is a rent tribunal which can take a specific decision in the case of dwelling houses, but not in the case of commercial premises. He takes a decision. It is contended that the premises are not dwelling house. The premise is not a dwelling house. It is used for commercial purposes. To what extent would the court interfere? The court would definitely look into the decision-making process. The subject is ever growing. We have a whole area of judge-made laws. I'm extremely sorry for the technical glitches at my end, which interrupted the address to some extent. But I've overshot my limit. I would like to stop. But I do hope that there will be more discussions in the future to into the area of how good governance can be enforced, how administrative authorities are to be kept within the limits of their powers to enforce good governance and to ensure that the administrative authorities act in the best interest of the people and not in an arbitrary manner. This requires further study. The law is ever growing, and we do hope that administrative law will be decided which promotes good governance. Thank you.
Thank you so much, ma'am. It was indeed a great pleasure to hear from you the abundance of knowledge and expertise reflected in your observations and suggestions about administrative law. Will actually go a long way in shaping and redefining perceptions of the audience. I, Ayushi Kushwaha, on behalf of the NUJS, extend a warm thank you to you. And I would like to now invite our Vice Chancellor, Professor Dr. Chakravarti, sir, to share his thoughts about the event and the theme.
Thank you, madam, for joining with us. We have this 2 days international conclave on contemporary issues on administrative law, and from yesterday till this validity session, lot of issues being raised by many of our distinguished speakers, and also you have rightly concluded that there are lot of things to come and we have to do study for good governance, and also how we can in our Indian context develop administrative law which fit our people and our legal system. Hope to see you in our campus. Because of this pandemic we are now on virtual. I hope that the situation will improve and we'll be in the campus to meet and also offer at least after the long speech tea or coffee. Now we are just to have all in virtual. So to conclude the session and vote of thanks, I will request my colleague Chengappa for vote of thanks.
Yes. Thank you, sir. So you have to mute. With this, we are coming to an end of the 2 days international conclave. First of all, I would like to thank Honorable Lordship Madam Justice Indira Banerjee for graciously accepting invitation and sparing your precious time. Thank you, Madam. I will be failing my duty if I don't thank everyone who have helped me to put the conference together. First of all, my big thanks to our Honorable Vice Chancellor, sir, for entrusting us with a big responsibility and providing solid support. Under his able leadership, NUJ is organizing various workshop, training program, webinars in order to build and contribute knowledge system of the society. Thank you, sir. I thank all the resource person. We had 24 resource person, combination of the honorable judges, professors, policymakers, bureaucrats. All they have immensely contributed for the success of the program. I also thank all my faculty, the colleague, my friend Sanjit Chakravarti for being with us. Then further, I would like to thank all the participants. I hope all the participants have got a good take away from the conference. Generally, conference like administrative law hardly be able to find. Most of the conferences with respect to constitution and other issues. This one we specifically dwelt on the administrative perspective. Finally, my sincere thanks goes to all hardworking organizing committee led by Samarth and IUC. Especially Samarth and IUC, they have come to my rescue so many times. And then special thanks to the IT team led by Neeraj, Mehul, Shreya and others, and all the volunteers who are sitting in this the auditorium. I sincerely thank each and everyone. Thank you, one and all. Over to IUC.
Thank you, everyone. Thank you, ma'am. Thank you, sir. It's a wrap now. And see you next time. Good luck to everyone.
Thank you, madam.
Thank you.
Thank you very much.
Thank you.
You have
Extremely sorry for the technical.
Sometimes we
Not a problem, ma'am.
Not a problem, madam.
We have to accept the internet. Thank that you have accepted that in your Sundays also. You know, Sundays very much valuable for you for.
We have no Sunday.
No Sunday. Yes. Every day is working day. Yes.
This is a good change.
Yes.
It's some intellectual exercise.
Okay, madam.
I wish I could attend the programs, but you know that is session.
Yes. We will also wish you to see in our other programs. We are now planning after March on campus programs. Please visit us in our campus. You were also part of our deciding executive council for long years.
Thank you.
Thank you, madam. Thank you. Thank you all.
Thank you so much.
Thank you, sir.
Thank you, sir.